Garden State GSCLE. 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 Garden State GSCLE.
I have to tell you that all the fact patterns we're going to be discussing today are real live cases. And you say to yourself, could attorneys really be that stupid? And duh, yeah, that's right. That's why we have these cases today. Now, just to contextualize things a little bit, I want to start off with just a quick review of a couple of legal issues we need to know about, because you're going to see these come up as we discuss things today. I want to start off with our state constitution. Nobody has the authority to discipline anybody other than the New Jersey Supreme Court. A couple words about this. First of all, you can see that by its language it's limited to the practice of law. There's nothing in here about disciplining members of the judiciary. That power was assumed by the court as implicit in this constitutional grant of authority developed through the case law. So the court has taken it through the case law. It's interpreted that this constitutional grant of authority allows them to discipline members of the three divisions of the Superior Court, as well as the municipal court and the tax court, municipal court and tax court being kind of inferior courts or legislative courts as opposed to constitutionally established courts. It also applies to surrogates, county surrogates, who, although they're elected officials, are also members of the judiciary and fall within the court's disciplinary purview. It does not include purely legislative courts like the Office of Administrative Law or Workers' Comp. That's not within the general authority of the court to discipline in terms of the judges. Interestingly, the court has never decided explicitly whether they have the authority to discipline their own members. And as you guys know, every 18, 20 years, one of the justices will do something silly and wind up having to be disciplined by members of the court. In fact, did you see that Associate Justice Robert Clifford died?
Okay.
Yeah, which made me feel bad.
Great writer.
Yep.
Great writer.
But he was involved in a traffic issue back around 1990 and had to be disciplined by members of the court. So in those instances where the justices have had some level of discipline imposed on them, no one has ever challenged that. They've just kind of consented to having the court discipline them for whatever the misconduct was.
Yeah, who hears that trial? I mean, the Supreme Court is the ultimate arbiter. Who hears that trial?
Well, you know what, I think it's usually the pressure on the justice is so huge to get it over with because it's an embarrassment to the court, and nobody wants to like drag out these embarrassing things. So typically these cases get resolved very, very quickly, and everybody moves on with his life.
Even Superior Court judges with speeding tickets, you know, they might have an absolute defense. They don't care. They just want to plead and get it over with. They don't want to make an appearance. They don't want to fight. They don't want to be out there. They don't want to be contesting things. So they have actually less rights in a practical way than the ordinary citizen because they have to fly under the radar in order to preserve the dignity of their office.
Now, I just want to talk real fast about how our disciplinary system in New Jersey for attorneys works as a practical matter. The vast majority of the cases will start off on the local level and be investigated by the District Ethics Committee. And there's a screening process so that cases that don't have any merit to them can get really weeded out of the system fairly early on in the process. But for those cases where there is some merit to the complaint, typically if there's a formal complaint, the matter will be publicly resolved. Typically you have a right to a fact-finding hearing before a panel that's involved with your case. The panels are usually made up of 2 attorneys from the District Ethics Committee plus one layperson. In cases involving arcane legal issues or complicated facts, the Supreme Court will appoint a special master to come in and hear the case. And my experience has been that the use of a special master gives you a much better quality of justice, so to speak, especially when you're dealing with anything that's at all complicated. Win, lose, or draw, your case after it's been decided by the panel at the district ethics level, they'll make conclusions of fact and conclusions of law and a recommendation for discipline or not, depending on what their findings are. Goes to the disciplinary review board in Trenton. The DRB is really the workhorse of the disciplinary system in the sense that they will decide every single case that comes before them de novo on the record that was made below. And they do exhaustive research on every case and write an opinion on every case that comes before them. So they really serve that function that the Supreme Court used to have in terms of writing disciplinary opinions. Very rare for the Supreme Court to write a disciplinary opinion anymore. The DRB will review the facts de novo, review the law, which, you know, that's also de novo review, and then come up with their own conclusions as to what the appropriate level of discipline should be. They will then send the case to the New Jersey Supreme Court for the issuance of a final order of discipline. Under 98% of the time, the discipline that's been recommended by the DRB will be adopted by the Supreme Court and imposed by the court. Now, I'm not suggesting for 1 second that you don't have the right to ask the court for a review of the DRB's determination, but normally that does not happen. The bottom line on all this is that when you're representing a client before the disciplinary review board, you got to say to your client, look, the statistical likelihood of the Supreme Court imposing the level of discipline recommended by the DRB is like 98%. So you've really got to give your best shot before the DRB, okay? Because the Supreme Court is just not going to reconsider it. The only time you have an appearance as of right before the Supreme Court is when the DRB has recommended a disbarment. Every disbarment case will go to the Supreme Court and you get a de novo review before the justices in disbarment cases. That's the last place you want to be, believe me when I tell you. But
And the last reason you want to be there.
it happens once in a while. Says, every once in a while somebody beats the rap. It doesn't happen all that often.
87 charges, no convictions. I'm a very proud man.
But in any event, I wanted to just kind of give you guys the procedure, so to speak, that's coming out of this grant of authority. Now, the first sentence here is also very important, dealing with the making of rules. Superficially, this is the grant of authority the court has to promulgate the rules of court, which they do every year, and as necessary on an interim basis when things are necessary to do that. For our purposes today, though, the second portion here, okay, the practice and procedure in all such courts, that is the authority that the court has to take the rules of professional conduct, the RPCs, and impose them on New Jersey attorneys. Now, just a quick word about the RPCs. They are national in scope, just like the New Jersey rules of evidence are based upon the federal rules of evidence and all the numbers are the same throughout the United States. It's exactly the same with the RPCs. They're promulgated by the ABA in Chicago. They were adopted effective 1984, and the numbering system that we utilize is national in scope, as the language is national in scope. Now, this is very important because sometimes you'll see statements in the RPCs that are inconsistent with local New Jersey law, all right? And I'll explain to you when we see one of these things, you really shouldn't be arguing that this is kind of a misstatement of New Jersey law. New Jersey is going to apply its own law, notwithstanding the fact that what it says in the RPCs doesn't necessarily comply with New Jersey law. I'll point that out to you. You're also going to see as we go through this that there's going to be an interplay between the RPCs and the rules of court. Sometimes they cross-reference each other. Sometimes you'll need to look at both a court rule and an RPC in order to figure out what you're supposed to do or not do, okay? And the first good example of that is Rule 1:14. 1:14, as you can see, takes the RPCs and applies them to members of the bar of the state. And you can see here the rules of professional conduct, you go down to the bottom, shall govern the conduct of members of the bar and judges and employees of all the courts of the state. The RPC application to attorneys applies both to your private lives as well as your professional lives, and you'll see quite a number of cases that come up where there's RPC violations that have nothing to do with the practice of law, but yet you're still supposed to follow the RPCs even when you're asleep at night, I guess. Okay.
Yeah, try getting picked up with some cocaine in your pocket. I mean, it has nothing to do with your job as a lawyer. You're on vacation in Florida, whatever. It's going to come back to haunt your profession. That's a violation of the RPCs. Your private life, but your professional life suffers.
Or try running away with a client sometime. You know, leaving your clothes on the beach and running off with a client.
You mean faking your death? And
Faking your own death. Yeah.
Ultimately being found in Delaware, I think it was?
No. It was much better than Baltimore.
Baltimore, oh yeah. That made no sense.
Now here's a real problem. It's Rule 1:18, which takes away any discretion from members of the judiciary when they witness what they deem to be a violation of either the rules of professional conduct or the New Jersey Code of Judicial Conduct. So judges just have to report every one of these things that they see. If they don't, they themselves would be in violation of Rule 1:18 and could be disciplined themselves for that. Actually, Joe, we're going to talk, this is how the GSCLE case came about, as a judge who saw that and thought it was in violation of the RPCs, and that's how the whole thing kind of got started. The requirement that attorneys report misconduct is much more nuanced and complicated, and we're going to kind of get into that in a second. Now what we've got here, guys, is a series of fact patterns that I want to kind of read and discuss, and then you and I and Joe will try to figure out what the answer is, okay? So here we go. Let's start off with fact pattern number 1. Alex the per diem painter.
Alex the per diem painter. Alex is 28 years old and lives with his mother and stepfather. His father, a New Jersey lawyer, has represented Alex in the past on a variety of traffic tickets. Although he is an exceptionally talented house painter, Alex has had trouble remaining employed. His stepfather proposes that the two of them begin a business where the stepfather will promote Alex's painting service in exchange for a 25% commission of the contract price. After agreeing on a handshake, aka a New Jersey contract, the stepfather forms an LLC with both of them as principals. What ethical issues are implicated under these facts?
What do you guys think of this? What
Should be in writing too, what you're talking about, probably.
Probably should be in writing,
If
okay.
he was going to go into business with someone who's not very good at their job, that's another thing.
Well, let me ask you guys a couple of questions on this. I mean, what are the inferences you draw from looking at this, okay? First of all, the fact that he's represented him on tickets before, does that make him his lawyer in perpetuity? Or is it just, you know, a guy represented before, but we don't have an attorney-client relationship anymore? What do you think?
I don't know, like that with a really bright line, because, well, I'm not his lawyer, except if he contacts you constantly, somebody reviewing your conduct would say he reasonably expects you to be his attorney. I think you have to be careful with.
Okay.
I think
Well,
it's disclosure issues.
I'm telling you, the Office of Attorney Ethics would be all over that. Well, that's what I want to talk to you about. I mean, you got a 28-year-old guy who's a painter, and he may have a PhD. I'm not saying he doesn't, but you know, the likelihood is he's not going to be as well educated as the attorney. Okay, so you don't really have an equal bargaining or knowledge basis between the two of them, right? This is really not an arm's length transaction. Everybody agree with that? But more importantly, they're living in the same house. Okay, and I guess he's living there because he's having trouble getting a job, and you know, he's living there with his mother and his stepfather. So you really have kind of an, I don't want to call it undue influence, but there's certainly not, from the power perspective, this is not an arm's length transaction. Am I making myself clear here, Joey?
This is the stepfather. I mean, this is, you know, he's the law. He's running the household, although mom is the real power behind the throne.
All right, let's say together. Come on,
stepfather look like he is.
Right. You have a situation now so that there's no way that anyone's going to look at this as an arm's length transaction because of the power differential, because of the educational differential, and the fact that he's represented this guy in the past. Now, my feeling is this. It's all in the family, so to speak, all right? Who cares? Nobody's ever going to complain. What's the worst that could happen, all right? So what's the worst that could happen here?
So you mean there's never any problems in families? People turn on each other?
That happens? I never heard of that before.
Disagreements over money.
Let's talk about that, because it's going to go one of two. Well, it's going to go one of three ways. Either nothing's going to happen, or it's going to hit and they'll make a lot of money, or they're going to go broke. Okay. But no matter which way you cut it, especially if they start making money, that's where there's going to be problems. Who's to say that 25% is fair and equitable? And because he's not doing any work, he's sitting around collecting a check. The other guy's out, you know, busting his butt and all that. Now they had 10 employees, 15 trucks. You know, they got all this stuff going. I mean, as lawyers, you have to kind of think, how's this going to play itself out? You know, Ray?
Listen, this is when you get involved with family members, you're always looking for trouble anyway. Those of you that do estate work and you see the squabbling that goes on after someone's death, and the brothers and sisters want to kill each other. No, it's even worse when you're alive. And as Bob said, there's two things that can happen. One, the business could go bad, and that's only a minor problem compared to it being a huge success. You know, what's the old saying that success has 1,000 parents, but failure is an orphan? You know, no one wants to take, you know, I had nothing to do with this failure, but if it's a success, I was the genius behind it, and that's where you have the problem. If this business takes off and the profits roll in, everyone thinks they're entitled to a greater percentage of the credit and the money.
My mother-in-law the other day called me up and said, listen, I'd like you to review our will. We want to make some changes. And I said, you know, is this really necessary? Do I have to do this? She said, oh, yeah, well, you're the best way to do it because you're the executor. I said, you know, forget about it. Okay, lose my number. I don't want to be your executor, number one. And number two, find a different lawyer. I don't want to be involved with this kind of stuff. Nothing with the family, you know. So you have to do for clients.
So you change the will. Everything goes to you.
Sure.
Cuts out their own daughter. And,
so you were there listening in, weren't you?
Yeah.
Okay. Now, question. If your clients your client came to you, either, let's say the lawyer came to you or Alex came to you, is there a way that you could do this legally and ethically? I mean, could you, what would you do?
Tell the stepson he has no lawyer.
Okay. And suppose he says, I don't need no lawyer. I trust you.
we don't need no stick.
They'll lay it out in writing. I think you'd have to do a little bit of due diligence in terms of, is 25% representative of what a person drumming up business gets? I don't know.
Is that net? Is that gross? You know, what expenses are...
You know, stepson baking business, I don't know.
Yeah, Joe, I saw the movie Jersey Boys the other day, and one of the things, Frankie Valli's making a deal with this songwriter, you know, and Frankie Valli says, you know, let's have an agreement. He says, no, we don't need it. We have a Jersey agreement, Jersey contract. They shake hands. You know, that's...
Which means if it goes bad, one of them gets killed.
That's right.
That's the Jersey agreement.
Let's take a look at the RPCs that are implicated by this and see exactly how you can put this together. Here's RPC 8.1, and the thing I want you to get out of this is that there are the need for writing, which you all picked up on, but there's actually 3 different writings that you need to put this transaction together. Now, I don't suggest for one second that you necessarily have to have 3 different documents that deals with each one of these things. I think you can cover it all in one document, but you should certainly have different separate paragraphs initialed individually by the parties so that everybody's cool with this. So here we go. Lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client. So this all is predicated on the idea that because you represented this family member in a traffic tickets before, that you maintain an attorney-client relationship with him. That would probably be your best defense in these cases. So here's what you have to do. The transaction and the terms in which the lawyer acquires an interest are fair and reasonable to the client and are fully disclosed and transmitted in writing to the client in a manner that can be understood by the client. So plain language, and it can be, you know, self-dealing. It has to be palpably fair. Now, what's fair today may not seem fair in the future. Again, if they start making a lot of money, that 25% may look like it's excessive, given the effort that the attorney is putting in on the case. Here's the second writing. Client is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek advice of independent legal counsel of the client's choice concerning the transaction. This client's choice business is very important. You can't be saying to your guy, listen, go see you know, Joe Schmo down the street here. He'll hook you up, you know, stuff like that. The client's got to go out and find his own lawyer and have it a truly neutral, you know, independent selection of counsel. Now, there's nothing that requires the guy to actually do it. You just have to make him aware of his right to do it. And then finally, client gives informed consent, again, in writing, signed by the client, to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in that transaction. So, no New Jersey handshakes for this stuff. It has to be in a writing signed by the client. Now, what I would do if I were putting such a document together, just to like anticipate the future, you could never go wrong by citing either case law in the body of the document or citing the actual language of the RPC and cross-referencing to the RPC. I would put in there something like that. To be in compliance with RPC 8.1, we are taking the following steps. And then I put 1, and then, you know, have the language under what we're doing to comply with 1 and 2 and 3. So that there's never there can never be a doubt that you were doing this to be in conformity with the rules of professional conduct.
You know where this may come up in the practical world is you may a client may come in with a huge case, and you know it's going to take an enormous amount of work, and the client doesn't have a lot of cash on them, and they offer to give you a mortgage on their home. And that would be security and collateral for your legal fees. In those situations, that's a practical one that we all might encounter on any given day. You need to tell your lawyer, excuse me, your client in writing that this is a business transaction between the two of you. The payment of your fee is a business transaction, and you have to lay this out. You know, it is my strong recommendation, that's the way I would phrase it. It's not that you have the right. It is my strong recommendation that you seek legal counsel to review this situation, to review the promissory note, to review the retainer agreement, to review the mortgage. You understand that you don't have to enter into this, or you can go to other lawyers if you want and have them represent you. All of that in order to protect yourself. That's a practical application of this.
My experience has been in dealing with this RPC 1.8, there's three things that trigger it: greed, stupidity, and desperation. Those are the three things that come into play. So you'll have like an attorney's representing a client, and the client really has a good idea, and the attorney wants to get in on the ground floor, so to speak, and tries to enter into a business relationship with his client while he's still representing him. Or the client needs money, and the lawyer decides he's going to lend him money and yet continue to represent him. Or alternatively, the lawyer needs money, and he's going to borrow money from his client. That's, again, just desperation. And then sometimes just lawyers just use extremely bad judgment because they're distracted by greed or being idiotic, I guess, is the best way to look at it. What the client has to understand, okay, are the terms, all right, the transaction and the terms. You're just putting this language in here just to kind of frame it out so that there is a reference to the RPCs in here to kind of protect yourself in case it blows up in your face sometime, okay? All right, so here, let's look at the case law here. This is a decision, and I want you to be particularly sensitive to the year this happened, 1980. This falls hard on the heels of In re Wilson. Joey, could you read that to everybody?
Lawyers have a duty to carefully explain, clearly and cogently, why independent legal advice is required. When a lawyer has a personal economic stake in a business deal, he must see to it that his client understands that his objectivity and his ability to give his client his undivided loyalty may be affected.
Now, tell me that the Chief Justice Wilentz did not write this next sentence.
This court will no more tolerate the hoodwinking, that's not a strong term at all, the hoodwinking of helpless clients out of funds in a business venture that is essentially for the benefit of the lawyer than it will outright misappropriation of funds.
So this was written at a time period when In re Wilson was very, very much on the minds of the justices, and they're really equating this type of situation, taking advantage of clients, to a knowing misappropriation of entrusted funds, okay? This is a per curiam decision, but you can get a good idea who wrote that part of it. Did anybody know Jack Frost, by the way, the attorney? I think he was more of a centrally located in the state. What was the name of that maniac that bothered your wife?
Lester T. Vincenti.
Yeah, can you talk about him for a second, because this is another version of that.
Okay, Lester T. Vincenti was an attorney. My wife was a DAG representing DIFUS, and she had a case against Lester T. Vincenti, and to say that it was a nightmare would be an understatement. And during the course of their 2 or 3 month trial, he would do things, you know, every now and then some people would be obnoxious. I'm going to give you some idea of some of the bizarre things that he did during the trial. He would interview by telephone some of the witnesses, and if they didn't give a version that was favorable to his client, he would subpoena them to be at the court at 8:30 in the morning to testify, and then he would leave them sitting outside until 4:30, go out and laugh and said, "I never intended to call you, I just wanted to punish you for not supporting my client's position." He physically attacked my wife, physically attacked another attorney during this time. The day the trial was over, which went on for months, the day it was over, he punched a sheriff's officer in the same courthouse. He, at one point, my wife objected to one of his questions. You know, you stand up and you object to a question. Your Honor, I object to that. And the judge considered the arguments and then ruled in favor of, the Attorney General's office on the objection. Just to a simple question. At which point he put on the record, Your Honor, he says, I understand completely why you have ruled in Mrs. Rem's favor. The two of you were sleeping together and having a torrid sexual affair, and this is why you did that. The judge never held him in contempt, didn't censure him for that. Just, he absorbed all of these. This was an attack on the system. He called the state psychiatrist, the prostitute. Isn't it true that you sleep with men for money? No. Isn't it a fact that, you know, you consider that sexual services in a profession? I don't sleep with anybody. I don't. And he would just make things up. He told, in his summation to the judge, he said, Judge, he said, just like the great German somnambulist of literature fame, you sleepwalked through this trial. And nothing I say to you in my summation you will be able to relate to, because you were not cognizant of what was going on around you. Never once did this judge in all these months hold him in contempt. Subsequent to this, he was censured for this. Oh, wait a minute, last one. They went up to the Supreme Court on, again, an evidence issue, went up to the appellate division, went up to the Supreme Court. In the middle of trial, on an emergency basis, Justice Schreiber called him into chambers and said, listen, because it's an emergency, there's an ongoing trial, all right, tell me why you think you're entitled to an emergency hearing on this. And they both laid out in chambers, you know, and the justice sat there with his yellow pad taking notes. And at the end, he said, thank you. He said, you know, I'll give you my decision this afternoon. And as they left, Lester T. Vincent, he turned around to the judge, he said, Justice, he said, could I have a copy of your notes? And the justice said, yes, but why? He said, I believe that you only copied down things favorable to the state and not to me. You've intentionally slanted your notes, and that may affect your decision. And I demand a copy of your notes. Yes, sir, we'll have a photocopy made. And then as soon as he walked out, Justice Schreiber said, hello, Colette. Colette Coolbaugh was the head of the attorney district. I think we have a problem. Anyway, they ultimately had to hand this to a special master, because at this time there was like 30 ethics complaints pending against him. He wore dark sunglasses every day. I mean, this was a... Anyway, he got censured here, and then he got another ethics violation, then he got another ethics violation, and then finally on his fourth... When I say ethics violation, I mean reported cases. And then finally... the court bizarrely gave him more severe ones.
You know,
and then
I think his first time through, I think they suspended him for a year. Then he goes back the second time, they only gave him 90 days.
Right.
And then the third time, they couldn't take it anymore.
No, it was the fourth time they couldn't take it anymore. And I forget who it was. It might have been Barry Albin, I forget. Just simply said, you're hopeless. You're a disaster. You're a danger to every practicing attorney, to judges, and to litigants. The consuming legal public is endangered by you. We're done. We wash our hands. You're done.
I bring this up because the Frost case is the culmination of probably, it may have been as many as 5 different trips to the New Jersey Supreme Court on ethics issues, okay? And he'd been disciplined over and over and over again publicly. And you just get certain guys that just, they don't get it, you know? I mean, what he did here might not have necessarily resulted in disbarment if it was first time through, but this was like his 5th time through, okay? The bottom line was they just said, that's all we can stand, we can't stand no more. Joey, could you read that?
Do you think it had to do with his name? Do you think growing up with that name just embittered him and made him a little bit off?
I don't know.
RPC 1.8a prohibits an attorney from entering into a business transaction with a client unless, among other things, the transaction and the terms are fair and reasonable to the client. Indeed, a lawyer is required to maintain the highest professional and ethical standards in his dealings with his or her clients. Furthermore, all transactions of an attorney with his client are subject to close scrutiny, and the burden of establishing fairness and equity of the transaction rests upon the attorney. If the burden is not satisfied, equity has regarded such transactions tainted so as to constitute a constructive fraud. In sum, respondent took advantage of an unsophisticated client whose trust he gained through the attorney-client relationship.
Yeah, and this may not have been a disbarment case normally, but it was just at the end of the line for this guy. He had just been through the system too many times. And they just said, look, this is a guy who just cannot conform his professional conduct to the requirements of law. We have to protect the public from him and send a warning out to attorneys who are like him. All right, Howie, read this to everybody, will you?
Larry the lawyer has been retained to represent Joyce on charges of drunk driving and the disorderly persons offense of resisting arrest. Joyce is also a New Jersey attorney. The case is now 4 months old and has been adjourned twice, once at the request of the prosecutor and once because of Joyce's unavailability. Joyce has demanded that Larry file a motion to suppress evidence and a motion to dismiss the case on want of a speedy trial. Larry has declined to file these motions in the exercise of his professional judgment. Joyce has accused him of laziness and cowardice for not representing her zealously. What issues are implicated under these facts?
How do you handle this issue, Joey? Because you've represented a lot of lawyers.
You know, at any given time, I mean, forgetting ethics matters, I'll have in my office, as I have now, I probably have a half a dozen lawyers as clients between DWIs and drug offenses, you know, for the most part. So it's, you know, we're all human, we all make mistakes. Most of these are minor and they don't, you know, really transgress the level of ethics. But, you know, lawyers need lawyers just like regular lay people do. When it comes to being an attorney and representing an attorney, you should know, as with every single client, that you are allowed to make all of the strategic decisions. However, as a practical matter, especially if you're representing a lawyer, you're going to do it in partnership. I always tell my clients, look, this is a partnership. We're working through this together. I'm going to give you my input. You're going to give me the facts. We're going to discuss these things together. And we're probably going to have the exact same, steer the same course together. However, and I tell them, whether or not you want to take a plea, that's your decision alone. I'll give you my advice. In fact, I'm ethically required to give you my advice. However, you have to understand that if you hear my advice and you want to do something differently, I will support whatever decision you make with 100% zeal. Number two, if we have a jury, if you want to go to trial, it's your decision whether you want a jury trial or not have a jury trial. I'll give you my opinion and input on that. And lastly, the other decision that's yours and yours alone is, do you want to testify? I'll give you my advice whether you should or shouldn't, but ultimately the ultimate decision is yours and I will not contravene it. Whatever you say, that's it. Everything else is my bailiwick, but you'll find that because I've tried, you know, a few hundred cases and you haven't, I'm going to have a better feel for it. But nonetheless, all the important decisions I'll discuss with you and we'll see if we can reach a consensus. And then the clients feel like they're your partner, and that's important because if you enlist them as your partner, you have to do a lot less work. For instance, you could sit in an interview and take 3 hours worth of information from them, or tell them, listen, before you come in, I understand over the phone what your issues are. I want you to sit down and start typing. Type out a chronology of everything that happened, and then wait a day, and then, because other things will occur to you, and then email it to me before our initial meeting. This way, if I'm going to spend 3 hours with them, I'm not going to spend time just senselessly writing. I'll have absorbed the fact pattern, issues will have occurred to me, there will be other questions, and I can go into more depth on those. That's how I handle it with clients. Lawyers, by the way, I have not found to be any more difficult or any better clients than an ordinary person. There's a case out of Alabama years ago, no, probably about a quarter of a century now, everything just seems like yesterday, where one of Alabama's leading criminal defense attorneys, you know, statewide fame, was arrested himself for a very serious offense. And he confessed. And they never Mirandized him. And it was the state's position before the state Supreme Court that they didn't have to Mirandize him because, you know, this guy's been doing this for 40 years. He's conducted hundreds of Miranda hearings. And the court said, well, he's only dealt with Miranda issues where he was the lawyer advising a client. When you are a client, that's way different than being the lawyer. You're not thinking straight. He needed to be advised of his Miranda rights. Now, that makes sense to me. On the other hand, it may well be that the Supreme Court liked this guy and didn't want to jack him up. I don't know what, you know, whatever the motivating factors were. But it is true. You don't assume that your client knows things about the law if you're dealing with a lawyer. And don't forget this, your client has two different kinds of culpability in this situation. One is to the local criminal authorities, and to the extent the municipal court and local police are the local criminal authorities, they have an obligation, drunk driving, disorderly conduct, assaulting an officer, resisting arrest, whatever it may be. But then they have another authority that they have to report to, which is the ethics committee and the disciplinary system. And you have to decide whether or not you have to report this conduct. And if so, you must do so. And you have to keep in mind, when you're navigating the outcome in the criminal matter, how that's going to impact their license to practice law. And you have to advise your client as to the fact that each decision you make is going to impact both, and you have to balance them.
Joe, what's the name of the mayor of Hoboken where they just had the case on him being disbarred the other day? Cameroso
Peter.
It was a Camerata?
Peter Camerata.
This is important because the Supreme Court announced a new rule of disciplinary law whenever the case was published, saying that people who are convicted or who get involved with, because you don't really have to be convicted, there's Rigolosi's example of that, but people who are involved in the bribery of a public official is going to be an automatic disbarment from now on. It's the same rule as in Ray Wilson. But I have to tell you, it's not a new rule of law because they have universally disbarred people who got involved in bribery of public officials after they were convicted at trial, after they were acquitted at trial. It didn't matter. They all wound up getting disbarred. But the reason I bring this up is the point Joe just made. I'm involved with a case right now where my guy's going to be indicted. And there's a whole bunch of stuff that they could indict him for. And he's trying to put a plea package together. And I'm really kind of saying, listen, you can't be pleading guilty to any type of a bribery account. You want to plead guilty to conspiracy to commit official misconduct or some theft offense, knock yourself out. Not bribery, because that's going to be a death sentence in terms of your ability to practice law in the future. Joe, I want to ask you a real quick question on the jury trial business, okay? Because that's in the RPC, and I want to kind of just talk about the law a little bit. My understanding of New Jersey law is that you don't have a right to a non-jury trial. It's a discretionary call.
By the judge.
Is it the judge, or could the prosecutor object and put the kibosh on it?
No, that's interesting, Bob. It's just interesting, coincidentally, because that issue just came up in my office this week. And I had this discussion with one of my associates. Here's the rule. The rule is the defendant always has the right to demand a jury trial. And if the defendant demands it, the prosecutor can't say differently, I want a bench trial. Because why? Sixth Amendment and Article 1, Paragraph 10, maybe, of the New Jersey State Constitution guarantees you the right to a jury trial. The state is not guaranteed the right to a jury trial, the defendant is. However, if the defendant wants a bench trial, and there's a host of reasons why a defendant might want a bench trial, the answer is this. The defendant can, in writing, submit a request that he be given a bench trial. That has to be on notice to the prosecutor. The prosecutor has to be given the right to be heard in terms of objecting to that, and then it's up to the judge. The judge will weigh all of the issues that are implicated, and the judge will make the decision as to whether to grant the defendant's application for a jury trial, a bench trial or not. So the prosecutor does not have veto power, but the prosecutor has the right to give his input as to why he feels a bench trial would be improvident, impractical, or for some other reason not the proper course of action.
Would it be a correct statement of law, though, to say, Joe, that in New Jersey you do not have an absolute right to a bench trial? You have an absolute right to a jury trial.
You have the absolute right to request the bench trial, and the judge has an absolute right to reject it for any host of reasons, none of which is set forth, but it could be practicality and it could be other reasons.
Okay, well, maybe the judge doesn't want the responsibility and wants the community to make the call.
Right, exactly, and it may well be that, this is a highly sensitized case and the judge doesn't want to be on the hot seat, and he feels that the public will be better served by having 12 members of the community make this decision, and there'll be a wider assent that the jury made a good decision and they weren't politically influenced, whatever it may be.
Right.
But yes, the defendant does not have a right to a bench trial. He just has the right to request one.
You're going to see this in the RPC in a couple seconds, and this is one of those examples where the RPCs are national in scope, but New Jersey law doesn't quite comport with that. Now, two things, though, that are really kind of beyond dispute. Number one is that your client, and again, Joe, I don't know that this is really all that controversial. There are two non-delegable rights that your client has in New Jersey. Number one, the decision whether you're going to plead guilty or not guilty to any accusation, indictment, count an indictment, whatever, that is strictly the client's call, okay? The client gets to make that. It's just an irrevocable right the client has. Do you agree?
Oh, duh.
And the right to testify at trial. And I want to just give you a little bit of an editorial comment about this business about testifying. We have enshrined this as a Sixth Amendment right, wrap the flag around ourselves, and talk about how important the right to testify at trial is. What everybody should know, the dirty little secret is that if you look at the history of the common law going back 1,000 years, the idea for the 99% of that time period that a criminal defendant would testify in his own trial would be deemed preposterous, utterly preposterous, unheard of. At 1789, when they were enacting the Bill of Rights, it would be unheard of for a criminal defendant to be permitted to testify at his own trial. Everybody recognized that they have, every reason to lie. They're not objective witnesses. Even as far as the 19th century, around the time the 14th Amendment was adopted, even at that point, only a very small minority of the states had entertained the idea that a criminal defendant could testify at his own trial. Now, in modern day criminal practice, we regard this as a constitutionally protected activity. But I just want everybody to kind of look at this, as this has not always been the case. And the problem that you run into, Joe, and we had a recent Bergen County case where this really played itself out. client insists on testifying, and if he does so, it may be, you steal defeat out of the jaws of victory. There was this Bergen County case I'm referring to. You guys know how infrequent it is that we see Halley's Comet. Well, multiply that by a factor of 100, and that's how often that you get a confession suppressed, okay? At least in Superior Court in Bergen County. It just doesn't happen, all right? It just doesn't happen, all right? I asked Bill Zarling one time, I said, Bill was a prosecutor for 36 years. I said, Bill, what's the best way to go about getting a confession suppressed? He said, oh, that's easy, bribe the judge. So in this particular case, this miracle happened where the confession was suppressed, and the Bergen County Prosecutor's Office puts its case on, for better or worse, and then the defense puts its goofy case on, and the case is going pretty good, okay? And then the defendant says, I want to testify, all right? And the attorney, instead of taking a baseball bat to the side of his head and rendering him unconscious so he couldn't, says, well, it's your case. You have the right to testify. When that jury heard that this guy confessed, their eyes were as big as saucers, okay, because they were believing this line that this guy was giving them. And then the prosecutor saying, well, didn't you say in your confession X, Y, Z? And that's just the opposite of what you told this jury just now, okay, Very embarrassing, right, Joey?
With those two decisions, to plea and to testify, I strongly suggest that you voir dire your client as to their decision. For instance, before you pick a jury, if you voir dire your client, so that you can put on the record that you've explained to your client what the deal is. Oftentimes clients will claim, my attorney never told me there was a plea bargain. I never heard of one. So you put on the record, have I advised you over the course of this case, the prosecutor offered you X, Y, Z? Did we discuss the benefits of it? Did we discuss the disadvantages of it? Did I discuss it with you long enough in time that you had the chance to go home and sleep on it a number of nights, discuss it with your family, ask me all your questions? You go on and on, and say, and what is your decision? My decision is to go to trial. Do you understand that by going to trial, all these consequences and greater exposure? Yes, all right. And the same thing with their decision to take the stand.
In municipal court, what I will do is, there's a certain level of kabuki theater, as you guys all know, but after the state rests, I'll take my guy out in the hallway. I'll say, Judge, my client has an important decision to make. Can I see him out in the hallway? And then I'll come back and say, look, Judge, I've told my client about his right to testify. I don't remain silent. I've explained to him that if he declines to testify, then Your Honor will not draw any adverse inferences against him, but will simply decide the case on the admissible evidence that's been presented to the court to this point. I've also explained to him that if he decides to testify, he'll be subject to cross-examination by the prosecutor on any aspect of the case at all. And knowing and understanding that, my client has decided to, and then X. Just so that it's on the record that we do it that way.
You've got to put things on the record. About 2 years ago, 3 prosecutors came over from Israel, and kind of an exchange program, and they were in Bergen County and watching trials and everything. And I had the opportunity to, as a member of the bar, I was asked to lead 3 or 4 defense attorneys and prosecutors from Bergen County to discuss with them and answer their questions and tell them about the system. And we had lots of interesting stories to swap and ideas about their justice system. Their jaws hit the floor. Their jaws hit the floor when they found out that a defendant has the right not to testify. They could not conceive of that. Because in Israel, they can call the defendant as a witness. The defendant can refuse to take the stand, but that is held against the defendant. There's an inference that the defendant couldn't exculpate himself. And in almost every case, they said in Israel, defendants hit the stand. Almost every single case. They were stunned that the prosecutor couldn't force the defendant to hit the stand. And they were stunned when we said, we really can't remember the last time a defendant ever helped himself on the stand. It's like, this is, they're inexperienced, the prosecutor's experienced, and just asking a question makes you look bad. What a difference. When they walked out of there, that was all they could talk about, is how they couldn't force, as prosecutors, in America, you could not require the defendant to take the stand.
All right, here we go. Now, I want to just talk about the substance of this for a second, okay? 4 months, for those of you who don't do drunk driving work, the ideal is that the case be resolved within 60 days. The vast majority of cases are going to be resolved without the necessity of trial, so more or less in 60 days is, I guess, doable, depending upon the volume of the court and a number of other factors. But a case that's going to be tried, especially when it has a level of complexity and witnesses and experts and things like that, for it to be 8 or 10 or 12 months or a year, that's not unusual and it's not unreasonable. Here, I don't know of any court in New Jersey that would regard a 4-month hiatus between the time of the charge and the failure to grant a trial as a delay, a speedy trial delay, especially when one of the, the applications for adjournment came from the defense. That's number one. Number two, either you have a motion to suppress or you don't have a motion to suppress, or you may have tactical reasons for not wanting to do a motion to suppress because either it has no limited merit or because you're reserving it for something in the trial. You agree with all that, Joey?
Sure, and well, I'll tell you, like for instance, in a DWI case, we all know that horizontal gaze nystagmus is not admissible under State versus Doraguzzi in the state's case in chief against your client. And an officer will testify, look, I gave him the test, and he hit 6 out of 6, which means that he's over the legal limit. Now, if you don't really have any real substantive issue that you think you can actually get this suppressed, you may not want to do that motion to suppress before a municipal court judge, because he's going to hear about that in the motion to suppress, and even though technically he's supposed to exclude that from his mind, the judge will remember, you know what, they say that this is the most accurate of all the field sobriety tests, and statistically it is, and he's going to have in the back of his mind, he failed that 6 out of 6, 4 out of 6 is a failure, 6 out of 6 is the ultimate failure. So you may decide for that reason, like, I don't have much of a chance of prevailing on this. In fact, I have practically no chance whatsoever. Let's skip that, and now the state can't even talk about HGN in the regular trial, and the judge will never know.
So if you allow your client to bully you into filing motions that have absolutely no merit, you run the risk of violating RPC 3.1, which is the prohibition against frivolous pleadings.
Now, wait a minute, if I may, there is, I believe, an exception, and you know this, I think.
That's the state versus Rue, the BCR exception.
That's right, PCR exception. Sometimes your client will tell you stupid, outrageous things, and you say, well, there's no legal merit, or you wouldn't. Doesn't matter. Your obligation not to present these is dwarfed by the courts that just say, the appellate courts. In fact, I know that when I began 35 years ago doing some public defender appellate work, the memorandum from the appellate division was, no matter how stupid an issue is, if your client wants you to raise the issue, you're relieved of the ethical bar of not advancing issues that you think are frivolous. If the client wants it, it's easier for you to just argue it to us. If it's frivolous, we'll take care of it. We don't want to have to go through this a second time on a PCR where they say, well, he never argued this issue that I wanted him to argue. They said PCRs, and in at least public defender appeals, they say, advance all the arguments and just trust us to sort out the wheat from the chaff.
What you're explaining, Joe, is precisely the holding in the Rue case. And there's a tension between 3.1 versus the PCR rule because, this is the defendant's last chance to say I'm being unconstitutionally detained or prosecuted or whatever it may be. So I had one of these cases one time where the guy actually had a fairly good PCR application, but he absolutely insisted that I raise as a count the fact there was no American flag in the courtroom, okay? So his conviction should be vacated on that basis. And this is before Rue came out, and I said, are you high? I'm not going to waste the court's time and make myself look like an idiot arguing this. I said, you want to follow your own PCR, follow your own brief, that's fine, knock yourself out. I ain't doing it. Well, I was wrong. I mean, the Supreme Court says, look, but as the tension between these two, it's more important that everything get before the court. Judges are perfectly capable of taking frivolous, idiotic PCR issues and dispensing with them if they have no merit, and then concentrating on the ones that do have merit. I mean, there's just an enormous amount of confidence in members of the judiciary who are hearing these PCR applications to make that determination.
Now, back when I was doing first started doing criminal work after I left the prosecutor's office, we didn't have these decisions yet. And every now and then your defendants would ask you at trial to do something that make a motion that just was stupid. And here's the way we would compromise. We didn't feel that we could, it was completely meritless. We didn't feel as attorneys we could advance this argument in contravention of the rules of professional conduct. What we did, our compromise was, we said, Your Honor, my client wishes to advance an argument or advance a motion, and let the client stand up and orally advance it. And I remember with Judge Amos Saunders, my client wanted me to disqualify the judge. And why? Because, when in discussing the judge, I said I told my client he'd been on civil for the last 5 years. He'd only been a civil attorney, he'd been on civil, and now he's coming to the criminal division. This is his first case. So he didn't like that. So He said, so he shouldn't sit on my case. I said, that's not a grounds. The fact that he used to sit in the civil division, they switch divisions all the time. He wanted to advance it, so he said, Judge, my client wants to advance an argument. And he stood up, he said, Your Honor, he says, I want you to, I forget the word, is it like, excuse yourself? And the judge was very polite. He's the nicest man. He said, recuse myself. Yes, that's exactly it. I want you to recuse myself. He said, why? And may I ask why? He said, well, Your Honor, I understand that this is your very first criminal trial ever. He said, yes, that's true. And how does that impact on your decision? He says, well, this is a quote, well, I don't want you practicing on me. That was his, I don't want you practicing on me. Well, the judge got this big grin on his face, and he said, I appreciate that, but blah, 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 and he dealt with the issue in a very pleasant way, never once putting down the client.
There is a tension in 3.1, especially in the criminal law, where so much is at stake when you're talking about the freedom of human beings, and occasionally when we have the death penalty, the life of human beings, that you don't want to chill the creativity and the outside-the-box thinking of the defense bar to bring every possible conceivable argument that has any merit at all to the court. And sometimes superficially they appear, you know, not to have any merit at all. You got to kind of think them through. So it says here, Joe, could you read that?
Sure. A lawyer shall not bring or defend a proceeding nor assert or controvert an issue therein unless the lawyer knows or reasonably believes that there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law, or the establishment of new law.
Can we stop here for 1 second? I just want to, just by way of example, there's a case pending before the New Jersey Supreme Court right now, which the court recently granted cert on, called State versus Witt, W-I-T-T. This is an appeal by the state of New Jersey out of a motion to suppress evidence, which is a stone cold loser for the state. Okay, they have no possibility of being successful in the merits of the case. But the reason they brought this goofy appeal is because they want to get this issue of the automobile exception under New Jersey law back in front of the Supreme Court to argue the Supreme Court should change it and make it conform to the federal standard. All right. Now, whether the Supreme Court does it, you know, who knows? We'll have to see how it plays itself out. This may be the case the court has been waiting for. But that's a perfect example where the state has taken firmly established law that goes back 40 years and saying, you know, you've been wrong for 40 years, we want to make a change. We're arguing for a change in the law, even though, you know, the law is very firmly established, okay?
Now, I got to tell you something. There was a case that I read in New Jersey maybe about 2 years ago where a PI attorney was being sued for malpractice by his client, and the court, you know, there was a motion to dismiss. I think the trial court below dismissed the complaint, and the appellate division reinstated it. And here's the scary part for all of us as lawyers. The lawyer below had advanced every single ground for a claim against, let's say it was a med-mal case, against the doctor. And so you would think he's particularly covered. The court reinstated the claim because they said that, because he had followed New Jersey law. However, the court said, no, we're going to allow the defendant to make the argument that on a national basis, that New Jersey law was being eroded in other states, and the attorney had an obligation to argue that the New Jersey existing law, well-entrenched New Jersey law, will soon fall away and fall apart, and it's going to change, and it should change right now, and its application is unfair. So the lawyer followed the law, was afraid to argue something that was in violation, contravention of New Jersey established law, and they were going to put him in the, you know, the malpractice crosshairs of a client because he followed New Jersey law and didn't predict accurately that New Jersey law might change because other states were starting to think differently about that area of law.
Joe and I were talking earlier on today about a dissent written by Chief Justice Walentz in a case. He was the only, he had 6 associate justices lined up against them, which is a pretty brave thing to do, knowing the way the chief was. But today, the Chief Justice's dissent is the law in New Jersey. The court has completely reversed itself and adopted this, at one point was a very lonely dissent, is now the law in our state. So the key here is the good faith component to it, okay? If it's a good faith effort to change the law, reverse the law, things of that nature, you're going to be protected from the 3.1. Okay?
And you'll never, no judge will ever say that you're being frivolous if you tell him, Judge, here's the New Jersey law as it stands today. Here's why I think it's wrong. Here's why people haven't thought through it in the past. And the judge will gladly listen to that argument. Right. I mean, had someone done that, you know, we have the McNeely versus Missouri about search warrants. New Jersey for years has said, You know, you don't need a search warrant when it comes to a car. Because it's, you know, it's mobile and it's always an exigency, and in a drunk driving case, you know, alcohol is dissipating from the blood, so that makes it more of an emergency. But, you know, we kind of followed like sheep over the years. We all accepted the fact the New Jersey Supreme Court has ruled this. None of us stood up and said, wait a minute, you know, that's just wrong. You're wrong. We just accepted, well, the New Jersey Supreme Court and the Appellate Division a dozen times have ruled this. We didn't challenge it. Had we done so, no one could have faulted us for that and said that it was not, that we were being frivolous, because even if we got ruled against and we said, look, the New Jersey Supreme Court's already ruled on it, you could say, yeah, but I think it's in contravention of the U.S. Supreme Court. Let the judge hear the argument and say, thank you, that's creative argument, or I represent, excuse me, I really appreciate your zeal, but I'm going to rule against you. Then you sit down, you've done your job.
The civil statutory component is here, 2A1559.1, which provides for sanctions for frivolous pleas. You guys, just in your notes, would you put down, you've got to read this RPC and that statute and pari material with Rule 1:4-8. All right, please put that in your notes. These are, all three of these are implicated by these types of things. And again, 1:4-8 really is kind of parallels 3.1 in terms of the ability to argue in good faith changes in the law. But it's got to be good faith, okay? All right. Now, on the scope of representation, Joey, could you read this? Because this is we really kind of discussed this already.
A lawyer shall abide by a client's decisions concerning the scope and the objectives of representation, subjects to paragraph C and D, and as required by RPC 1.4, shall consult with the client about the means to pursue them. A lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation. A lawyer shall abide by a client's decision whether to settle a matter. In a criminal case, the lawyer shall consult with the client and, following consultation, shall abide by the client's decision on the plea to be entered, jury trial, and whether the client will testify.
Yeah, and I think the jury trial part, this is national law. I don't know that that's really an issue in New Jersey because you're entitled to a jury trial right off the bat. That may not be the case in other jurisdictions in the United States. But certainly the plea to be entered and whether the client will testify, ultimately it's going to be the client's decision. This business with the decision to settle a case, that applies both in the criminal context as well as in the civil context. And it's more difficult in the civil context because the lawyer has a vested interest in the outcome of the case from a financial standpoint. And there may be some very sharp disagreements between attorney and client. Ultimately, the client gets to decide even if the amount of the settlement is unreasonable. Or alternatively, if the offer is reasonable, the client has the right to be unreasonable and wind up getting no cost on the thing. It's important that you communicate plea offers to your clients because, again, your client gets to make the final decision as to whether to accept some type of plea offer. All this comes out of RPC 1.2 scope. Now 1.4, and this is what you can put in your writing to a client when you're saying to your client, look, I ain't doing it, okay? It's frivolous, it has no merit. In the exercise of a professional judgment, this doesn't help your case either tactically or strategically. Cite 1.4, okay? You'll protect yourself. And actually put the language in your letter so that if somebody files an ethics complaint against you later on, you can show that you were concerned about this, okay? And you say to them, look, I can't do this. In my opinion, it violates RPC 3.1, okay? It would be a frivolous pleading. I can't do it. And I'm telling you, this consistent with my responsibility under RPC 1.4, okay? You got to protect yourself in these situations so when they come back against you later on, you're going to have a record upon which to defend yourself.
Now, with these letters, should I always send them certified no?
No. Just the importance is you have it, you know? Could I ask you to read this one? We're going to do fact pattern number 3 now.
Fact pattern number 3. BFF. Mo and Joe have been friends since 5th grade. As adults, they remain best friends and, along with their wives, socialized and took vacations together. When Mo and Joe began their professional careers, Joe became a lawyer and Mo a construction contractor. Naturally, Joe represented Mo's company in all its dealings. After a number of years, Mo acquired a valuable plot of land and invited Joe to purchase half of it from him. Under the plan, Mo would build 2 dream houses and the 2 couples could be next-door neighbors. The 2 friends agreed on a single price for everything, shook hands, and began their new adventure. with Joe making periodic payments to Mo. Unfortunately, after about 18 months, construction delays, substandard work, environmental contamination, and a question about the title to the property have now turned the two friends into bitter enemies and adversaries in Superior Court. What ethical issues are implicated under these facts?
Now, just to give you some background here, it was bad enough that these two guys had been best friends, but the wives were best friends too. Oh, very bad. Very, very bad. Yeah, it is. This guy, the attorney here, was in a very small New Jersey county, and he was a player in this county, okay? He was in line for a Superior Court judgeship. He was a transactional lawyer, very, very bright man, just a total player in his county, okay? And his life was ruined as a result of this. I represented him on it, and I didn't have the heart to charge him a legal fee because he had already paid $250,000 to defend himself on this. And I said, listen, you've already been ripped off enough, okay? Let's just stop. Let me go through, because it was really kind of a simple case when you come right down to it. A very, very nice man, and I just thought to myself, you must have been absent from law school on the third day when they say that, you know, real estate contracts have to be in writing, you know? I'll give you that you were sick, okay? You know, it was the World Series and you took off to watch the game, all right? But I think the driving force here, there's two things that were interesting about this case. The level of hatred between these parties was so off the chart. And it was all being driven by this sense of betrayal, of people who are lifelong friends having betrayed each other, okay? Not only among the husbands, but the wives too, which made it 50,000 times worse. And I remember the attorney kept saying to me, but he's a liar, he's a scum, he's a thief, he's a this, he's a... And I said, yeah, but you're missing the point here. He's not a lawyer. The RPCs don't apply to him in any way, shape, or form, okay? They apply to you. That's what the problem is here. It has nothing to do with him. It has to do with you. You're the one that's, yeah, but he's a... No, he's not bound by the RPCs in any way, okay? When he takes the bar exam and gets admitted, then we'll come back and talk about that. For now, he's a construction guy. So you have no written agreement.
No,
okay.
That's one.
They agreed, like, let's say it was $1 million. I think that was the price. So the lawyer's paying him now. So every 60 days he gives him 50,000, then he gives him 20,000, then he gives him 10, then he gives him another 30, you know. And he's making these payments along the way, and nobody knows what he's paying for. Is he paying for the land? Is he paying for the construction? Is he paying interest? You know, because there is no interest rate assigned to all this. They're just two guys.
Part of an LLC or a corporation?
Which?
In Mo and Joe, did he buy into the corporation also?
No. He was just representing the corporation.
No, when they bought the land, was the land owned corporately?
No, he bought it personally. Then he subdivided it.
Did they own it as a partnership?
No, he owned it himself, and then he subdivided it and sold half of it to...
Yeah, okay, so he sold off a lot
right.
to him, so he owned title in his own right.
Correct.
And there's no mortgage on it.
No, he had it outright. But there was an issue then about whether or not he actually acquired title. You know,
but he didn't pay for it at one shot, so it's an installment.
It was well, who knows what it was? You know.
I don't know.
Was it a mortgage? Was it an installment sale?
Sales contract.
One thing is for sure, it was a New Jersey contract. There was nothing in writing at all. And they figure, hey, we're buddies, you know. And their dream was, we'll be next door neighbors and we'll never have to be apart, okay? And the wives are into it. They're into it. Everybody's going to be friends. It's going to be so wonderful. And I have to tell you, ultimately the case was settled, and now they're in hell. They're in perpetual hell. There is nothing worse in the world than having ongoing warfare with your next door neighbor, okay? And they're stuck with each other. So now they're in municipal court every other minute. He shined a light on my property. He was taking a picture of my daughter. He was warming his car up, you know? Every minute they're in municipal court. Every minute, you know? It's living in hell. It's absolutely living in hell, you know? So, but forget about hell. Let's talk about ethics for a second, which are, you know, they're very similar. Is there a way to have done this like a normal lawyer would have done it? I mean, when you're advising this guy, what would you tell him to do?
First, it would have been in writing.
Right.
You would have had a contract. Then I would have certainly have had another lawyer on the other side. I would have advised them, depending on who I represented. I represented the contractor or am I representing the attorney? I would have told the other party that you have to have an attorney on the other side.
Right.
I don't want to deal with you individually. I really would prefer you hire another attorney. And assuming once that occurs, then everything goes ahead.
See,
I personally would walk.
the ethics issue in this case really had nothing to do with stupidity, because it's not against the law ethically to be mentally retarded. That's okay. All right, you can get away with it. Yeah, I'm thinking, Dougie, there's hope for you. The problem was that while he's going through this mishigash, he's still representing the corporation. He's representing this guy's corporation while he's giving the guy money for this, whatever type of agreement it is the two of them have. An agreement that's not in writing, not signed by the party to be charged, you know. That's really the ethical issue here. This is what he got jammed up about, is that he didn't, you know, he has a concurrent conflict is basically what happens. In other words, he's representing this guy's corporation, but yet he has a personal interest with this guy. Everybody see what I'm saying here?
What would
It's
happen-
got
what
to
would
be
happen if
list
you
of
didn't
what
make
we
the
did the
payments?
first time.
But it's different though, because this is still, that first one dealt with a slate. Yeah, right. It's a different RPC though. This deals with concurrent conflicts.
What
Okay.
would happen if you didn't make the payment?
Who knows? Who knows?
Sue your own client?
That's right. I mean, well, yeah,
Or is your own client sues you?
that's right.
You know, over what? You got an agreement?
Do you have a note or something?
No, a handshake, because we're friends. All right. It's a Jersey contract. All right, let's look at the RPCs. This is RPC 1.7.
RPC 1.7 Conflict of Interest. General Rule. A. Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if 1. The representation of one client will be directly averse to another client, or 2. There is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or a personal interest of the lawyer.
Now, A2 is what this guy got jammed up on, okay? But specifically, it's very unusual for this to happen outside the sexual realm of personal interest of the lawyer. Usually when this comes up, it is because of sexual shenanigans between attorney and client. So I'm before this huge Bergen County group of attorneys, and I'm telling the story of this guy. And this had happened 30 years earlier. And I'm saying, and so she walks into the bedroom, and there he is, stark naked. And like 4 people put their hands up and goes, no, that's not what happened. He had black socks on. I'm thinking to myself, how do you know that he had black socks? I said, oh, it was in the Bergen Record every day. Apparently they were like, it got tried in municipal court. And apparently the people were salaciously, are following the salacious story every single day. The funny thing about this case is that he wound up being disciplined, and the DRB establishes a rule of law that if you've been assigned a matrimonial case, you are not permitted to engage in sexual relations with your client, because these clients are so vulnerable at that point, and it just really is kind of a breach of trust. There is no general prohibition, though, about having sexual relations with clients. Now, every year when the ABA meets in Chicago, they always propose an RPC that would ban sexual relations between attorneys and clients, and every year it gets voted down. I used to say, based on my own experience of representing people, there's nothing stupider that you can do than engaging in sexual relations with a client. However, I'll always get a call the next day after I say that. I started dating my wife when she was my client. We've been married 27 years and we have 3 kids, all this stuff. All right, it happens. Every once in a while, the blind chipmunk finds a nut, But in this particular case, the personal interest of the lawyer, that almost always comes up in a sexual context where you're engaging in sexual relations with a client. Here, the personal interest of the lawyer was the purchase of the real estate, but yet he's representing this guy's corporation at the same time. That was really the gravamen of his RPC. Joey, I want to give everybody some legal advice here, okay? There's a court rule, I think it's 7:7-10, which allows you in municipal court to go in and represent more than one client. All right? You can represent multiple clients in municipal court. I can't imagine that happening in the Superior Court. I can't imagine it happening in federal court. Can you see that happening? You'd have more than one client in a criminal case in Superior Court?
Well, listen, I had a husband-wife that came in just about 3 or 4 months ago. Complete identity of issue, completely both on the same page. One could not possibly turn on the other, and I still said you needed a separate attorney. Even though there was no potential conflict that I could envision. And guess what? Now that, in fact, I just noticed that this morning the prosecutor reached out to me, and I'm having, they're willing to give one of the defendants can choose who gets PTI and who gets a dismissal. Okay? And if you're representing both, I mean, it's just uncomfortable. I will never, even in municipal court, I don't care what the economics are for the client, I will not represent two people. I don't care what their identity of issue is and the complete realistic lack of a potential conflict, because there's always a potential conflict no matter what.
See, I'm unlike you, Joe. My life is driven by avarice and greed. So the maximum for me, my record is four defendants. And there's a procedure that you can do, which I'll show you momentarily, to represent more than one person in a municipal court. What I'm suggesting to you, though, if you do that, besides following the procedure in the rules of court, comply with a 7.1b. Could you read that? This gives you how you do it.
Notwithstanding the existence of a concurrent conflict of interest under paragraph A, a lawyer may represent a client if 1. Each affected client gives informed consent in writing after full disclosure and consultation, provided, however, that a public entity cannot consent to any such representation. When the lawyer represents multiple clients in a single matter, the consultation shall include an explanation of common representation and the advantages and risks involved. 2. The lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. 3. The representation is not prohibited by law. And 4. The representation does not include the assertion of a claim by one client against another client represented by the same lawyer in the same litigation or other proceedings before a tribunal.
Now, what you've got to do, guys, is when you do your writing, my habit has been to put the language of this particular RPC in here and track it and have my clients, each one of them, initial that. Then you'll use the procedure. Here's the court rule 7:7-10. No attorney or law firm shall enter an appearance for or represent more than one defendant in a multi-defendant trial or enter a plea for any defendant without first securing the court's permission by motion made in the presence of the defendants who seek joint representation. So typically what I'll do, I'll have them all there, I'll question them, for the record, and then seek leave of the court to represent them all and enter my appearance. But in the back office, though, I go through this exercise under RPC 1.7b to make sure that I have a writing where they acknowledge this as well. Guidone is the main case dealing with the discipline of individuals who get involved in 1.7 violations. The level of discipline is a function of harm to the client. So, and it's the final harm to the client, not the initial harm. In other words, the client suffered some tremendous financial loss, but if you've made good on it, made the client whole through insurance or out of your pocket, that's going to be okay. That'll be a significant mitigating factor. All right, let's see. Who can I get to do one now? You want to try it?
Fact pattern number 4, the DV complaint. Larry the lawyer has come to you to represent him on a domestic violence case. He's facing a petty disorderly persons offense in municipal court as well as a TRO pending in family court. What ethical issues are implicated in this case?
This is what they'd say, the bar exam, a trick question, okay? Because it's a hybrid situation. It's complicated. You all have to know about this. So if a colleague comes in to see you that has a domestic violence situation, you know how to handle it properly. Everybody cool? All right. So let's kind of go through it step by step. First of all, I'd like you to excise from consideration the TRO part of it. I don't know that there is any ethical obligation or implication on a civil suit that comes about as a result of an act of domestic violence, okay? It's just its own animal, has its own standards of proof, and I just don't know of any implications ethically that a TRO would have in the family court, okay, or an FRO. I just don't know of any. I don't know of any case law that's ever come up. I'm not aware of any RPCs where that would be implicated. So far, so good?
You don't have to report it.
No, I wouldn't do a thing.
Judges either.
Judges are a different animal. Any litigation that a judge is involved in, including Well, it would have to be somewhere north of a parking ticket.
Does a judge have to report a TRO for an attorney who comes before him?
No. But if a judge who gets jammed up on any type of civil case, anything more than a parking ticket, that has to be reported to the assignment judge. Actually, can I go a little bit farther than that? Because you actually raised a very important issue. There is a directive from the Administrative Office of the Courts telling judges who have been charged with domestic violence, in the civil context, what their limitations are in terms of their ability to hear these types of cases. And it's different than drunk driving, Joe, in the sense that there's a recognition that sometimes these cases are filed, they have no merit, or they're filed for tactical reasons in a matrimonial action. But it's in one of my books, I forget which one, but there's a very involved procedure that judges who have been charged with domestic violence in the family court have to follow through on. Now, you have the rules of court, and then you have reality, okay? I want you to all forget about the rules of court. Follow my advice, and you'll never go wrong, okay? A client who comes to you who's been charged with any type of criminal offense, and I mean this in the context of New Jersey law, 4th degree or higher, your client has an affirmative obligation to report himself to the Office of Attorney Ethics. That's in the rules of court, okay? You, as the defense attorney, should undertake that responsibility and write to the Office of Attorney Ethics. Send them a copy of the criminal complaint and say, look, my guy was charged with X. Here's a copy of the complaint. I will keep you apprised of all relevant developments in the case, okay? Now, normally, unless it implicates the practice of law or harm to a client, there's an allegation you were stealing money from your trust account, they're not going to get involved with the case initially, all right? And there's reasons why they won't do that, which I'll tell you about momentarily. My practice, personally, is to also report DPs and petty DPs, okay? I do this for a couple of reasons. Number one, DPs and petty DPs can and sometimes must result in discipline, and you're going to see that in the domestic violence context. There's no harm in doing it, and you're better off doing it lest there be an allegation that your client was trying to cover up or hide his involvement with the criminal justice system from the Office of Attorney Ethics. There's no downside to it, okay? It's only a plus side. And part of the thing driving this is that the rules of court are not written well, as you'll see momentarily. There should be an implication in there that you should be reporting everything, DP, petty DP, and crimes, okay? That has been my practice. I'm going to suggest that you all follow it. Now, do it on behalf of your client. Write for your client. Your client has enough problems. By the way, do you disagree with any of this, Joey?
I take it a step further. I say, look, you don't have an obligation to do this. Nonetheless, it puts you in good stead in terms of should this matter result in a conviction and this come before the ethics committee, you'll look that you were out front, you weren't afraid of it, you didn't hide behind it. And a lot of my clients tell me, my attorney clients, I don't want them to know. No, I don't want you to do it. I said, all right, I'm advising you then to do it, and whether you do it is up to you.
Now, let's just hold off on domestic violence for a second because this is its own sui generis. It's its own procedure, all right? There are two things in play here. Normally, you have parallel proceedings. You have the criminal justice, either in superior court or municipal court going on, and then you have the attorney ethics issue. They will hold off on doing anything on the attorney ethics part of it for two reasons. Number one, because there's constitutional issues about your right to remain silent and not have to give statements that can be used against you somewhere down the line. So in order to accommodate all that, they just don't do anything with the attorney ethics part until the criminal part is over. But there's a second reason why they do that, because it would be a waste of everybody's time. Because, as Joe mentioned before, if you are convicted, either by way of plea or trial, your conviction constitutes conclusive proof of the RPC violation, which typically is going to be RPC 8.4b, which is, the general prohibition against violating the criminal law. Okay, it is conclusively established. You are collaterally estopped from introducing any evidence related to any defenses that you have to the charge. Okay, you stand up and plead guilty, or you get convicted, it's over. The only thing that you're going to be allowed to argue is factors in mitigation of the quantum of discipline you're going to receive. That's it. There's not going to be a hearing, there's not going to be anything, all the stuff is going to be done in writing. So this is an enormously important decision your client's going to make, especially if it's going to be a plea, and you have to kind of structure it in such a way that the impact on your client is going to be minimized to the extent that you can control that. But this is an enormously important aspect, and you've got to know this going in when you're representing a client. Now, there's a collateral issue associated with cross-jurisdictional discipline. If you have a client who is admitted in another jurisdiction anywhere in the United States, and he is subject to discipline in that other jurisdiction, he has an affirmative obligation to report himself to the Office of Attorney Ethics. He has an affirmative obligation to tell them what the disposition is. And again, if he is found to have violated the RPCs in the other jurisdiction where he's admitted, that conclusively proves the RPC for New Jersey purposes, meaning that the only issue will be what is the level of discipline you're going to receive. Typically, it'll be, it's reciprocal discipline. They normally will give you the same thing you got in the other jurisdiction. Not always, but normally that's what will happen to you. But you've got to tell your client, listen, you can't fight the battle twice. If you're going to contest this, you've got to do a good job in the other state, Ohio, wherever it is, because if they find that you violated the RPCs there, New Jersey's going to discipline you, and you're not going to be able to do anything about it. All right, everybody cool? Now, let's talk about domestic violence for a second. And let's just keep it simple. Let's just talk about municipal court domestic violence, all right? There are 6 predicate offenses that constitute acts of domestic violence in New Jersey. So simple assault, harassment, lewdness, criminal mischief, criminal restraint, and trespassing, okay? Six offenses. You have to link the predicate offense to the relationship between the defendant and the victim. I don't do domestic violence work, so I mean, just off the top of my head, married, used to be married, kid in common, dating relationship, she's pregnant by him, and there's probably 14 other more, but I mean, just off the top of my head, if you have the predicate offense and that relationship, that is an act of domestic violence, okay? Everybody cool so far? Now notice that the only ones that really would implicate any physical touching for the most part is going to be simple assault and harassment, okay? And the rest of them, lewdness doesn't really necessarily involve physical touching, as does criminal mischief or trespassing, all right? But notwithstanding that, they are all acts of domestic violence. Now, having said that, let's look at the case law here. Magid and Principato are companion cases that establish the rule of disciplinary law in New Jersey for DP level domestic violence. Principato involved assault of conduct on this guy's girlfriend, and I know him, so I kind of know what happened in the case. And there's no doubt he was hitting her. I think she hid behind a mattress that was all on the wall. He was punching the mattress, okay? But it met all the qualifications for simple assault, and he was guilty of domestic violence. Imagine a much more egregious example, a savage beating of this young lady in public outside of a bar by an individual who not only beat her badly, but also was the first assistant prosecutor, I think, in Gloucester County at the time. So you had the aggravating factor that you have a public official who's a law enforcement officer engaged in an act of domestic violence. And ultimately, I think they downgraded it to simple assault, although it was pretty clearly would have qualified as an aggravated assault given the severity of the beating. So the Supreme Court wrote two opinions. Again, these are companion cases, and they create this new rule of disciplinary law. And here it is. Joey, could you read that, please?
The respondent's conduct was a serious violation of RPC 8.4, but for the fact that we have not previously addressed the appropriate discipline to be imposed on an attorney who was convicted of an act of domestic violence, and that respondent did not engage in a pattern of abusive behavior, respondent's discipline would be greater than the public reprimand we hereby impose. We caution members of the bar, however, that the court in the future will ordinarily suspend an attorney who is convicted of an act of domestic violence.
Now,
can you say Ray Rice? I mean,
is this a bright line rule now? I mean,
yes.
Back then they established it.
And that's the only reason why they didn't suspend these guys, because they were on notice that this is going to be the rule of law. However, this is much more nuanced than it appears. They use the word convicted twice in this paragraph, all right? So you got to say to yourself, well, you don't get convicted of anything in family court, at least unless it's a restraining order violation. So they've got to be talking about something that's going to be in the province of the criminal law, either municipal court or superior court, all right? But the language here is very sloppily written, because they said attorney who's convicted of an act of domestic violence. What do they mean by that? When you look at it in the overall definition, it could be any one of those 6 predicate offenses coupled with the right relationship between the people. That is an act of domestic violence, all right? In fact, if you're in municipal court, you have that. There's all kinds of special penalties that the judge has to impose, Superior Court too. Is the Supreme Court talking about this in the context of lewdness or criminal mischief or something like that? Or are they limiting this to facts similar to the Magid and Principato cases, where there was assaultive conduct by one human being on another human being, okay? And the answer is, we don't know.
Yeah, think about the situation that I actually had in court one time. It was not an attorney-client, but you know, the wife got an FRO, or maybe it was, at the time it was a TRO, it doesn't matter. And one day when she's out of the house, he goes to the garage, because he was a contractor, and he took out some of his tools to take to work. And when she found out, he came and took some of his tools, not to keep them or steal them from her, but he was a contractor and he used those tools. She filed a trespassing complaint. That was domestic violence. Now, should you get suspended if you're an attorney and you go into the garage because you have some law books in there? That would be an act of trespass if there was TRO and you had to keep away. You don't have the right to the home anymore. When they say, you have to read in here, they will ordinarily suspend an attorney. When we talked about bright line rule, it's not like you will be, it's not like In re Wilson, you will be disbarred. Nonetheless, they're telling you, absent other circumstances, this is going to be the preferred method of dealing with your situation.
We just don't know what the parameters of it are. But let's get back to ethics for a couple seconds, okay? If you're going to err on the side of caution. Tell your client who comes in, who's charged with one of these things, you say, listen, buddy, you could wind up getting suspended here. Now, I'm not suggesting that you don't have defenses that you can raise. And look, if it's assaultive conduct, you know, forget about it, okay? They're going to suspend you at least for 90 days, all right? Depending on your history. It could be longer, but you're looking at a minimum suspension for practice for 90 days. If it's something else, some other predicate offense, it doesn't involve assaultive conduct, you know, you might be able to argue your way out of it because the law is not clear on that issue. But this is why it's important that you, A, be appreciative of the impact that a conviction is going to have, because it conclusively is going to establish the RPC 8.4b violation. And number 2, why it's important to report yourself to the Office of Attorney Ethics when you have these types of cases. Let's just look at the court rule for a second. Here's RPC 8.4b is the one that you normally get. It's applicable to any type of criminal or quasi-criminal conviction. Commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Now, let's just stop for a second. As you all know, the Code of Criminal Justice defines criminal act as being an offense of the 4th degree or higher. Be mindful that this is national law. Our courts will interpret this criminal here to subsume DPs and petty DPs, notwithstanding the fact that it doesn't meet with the classical definition of criminal under the New Jersey Code of Criminal Justice, okay? So, and you'll see how that plays itself out when you look at the court rules for a second. Sometimes they'll charge you with C also when you have thievery, you know, dishonesty, fraud, deceit, or misrepresentation, okay? Here are the court rules. This is the first one dealing with self-reporting on, and Howie, this is the situation you just brought up. So it's 1:20-13A. Attorney who's been charged with an indictable offense in this state or with an equivalent offense in another state, territory, commonwealth, etc., shall promptly inform the director of the Office of Attorney Ethics in writing of the charge. Attorney thereafter shall promptly inform the director of the disposition. So there's no doubt that when you're dealing with crimes, that's your responsibility. Here's why I say DPs and petty DPs should also be reported. Take a look at C in the same rule, okay? In any disciplinary proceeding instituted against an attorney based on criminal or quasi-criminal conduct. Quasi-criminal means DPs and petty DPs, guys. The conduct shall be deemed conclusively established by any of the following: certified copy of judgment of conviction, transcript of the plea of guilty, or to a crime or disorderly person's offense, whether the plea results in either a judgment of conviction or admission to a diversionary program. Again, Howie, that's you. A plea of no contest, nolo contendere, which we don't have anymore, or transcript of the plea. I guess nolo contendere, you would use that in federal court. And here's the part where you are collaterally stopped from raising defenses. Joey, could you read that, please?
Sure.
Well, number 2.
Yeah. At the conclusion of all criminal matters, including disorderly persons offenses, involving findings or admissions of guilt that are not the subject of a direct appeal, or at the conclusion of all direct appeals from all such matters, the director may file directly with the board and serve on the respondent or counsel, if any, a motion for final discipline based on the criminal conviction or admission of guilt specifying the sanction requested. Within 21 days after service of such a motion, the respondent shall file with the board and serve on the director a brief, together with any other permissible filings. The director may, within 21 days thereafter, file and serve any responding brief. If the respondent either fails to file a timely brief or timely files a brief which does not disagree with the sanction requested, no oral argument is required, and the board may decide the matter on the record. In all other cases, the board shall notify the parties of a date for oral argument. Following oral argument, the board shall issue its decision and recommendation for final discipline to the Supreme Court.
So they'll say X, they send it to the court. The likelihood of the court imposing X is extremely high, except if it's a disbarment case and you're going to get your day in court. And Joe, here's the main part.
By the way, as I read this, take careful note that when you're dealing in ethics matters, don't talk about, a suspension or a proctorship or a disbarment as being a penalty or a punishment. Be precise. It's a discipline, okay? They talk about it being discipline because the object is not to punish the attorney. The object of the discipline is to protect the consuming public, all right? So there's a difference in focus. So don't, if you use the word penalty or punishment, you will come across as not being completely conversant with the rules of ethics. So keep in mind that every time we talk about the consequences to the attorney, we use the term discipline.
Yeah, talk about it in terms of the quantum of discipline, the amount of discipline, the level of discipline. Punishment is the realm of the criminal justice system. This has nothing to do with punishment. It is only about protecting the public from attorneys, again, who can't conform their conduct to the requirements of law. All right, it's about protecting the public. That's all it's about, and nothing else. So it's unprofessional to utilize the word punishment in any aspect of attorney discipline.
The sole issue to be determined shall be the extent of the final discipline to be imposed. The board and court may consider any relevant evidence in mitigation that is not inconsistent with the essential elements of the criminal matter for which the attorney was convicted or has admitted guilt as determined by the statute defining the criminal matter. No witnesses shall be allowed and no oral testimony shall be taken. However, both the board and the court may consider written materials otherwise allowed by this rule that are submitted to it.
This is important when you have an expert's report. You might have a guy suffering from depression, drug addiction, psychiatric, whatever it may be, and you've hired an expert who's going in and diagnosed your guy, given a course of treatment and things of that nature. That stuff goes in, but there's no testimony. It all goes in as paper, and then you get to make an oral argument on it. All right? All right. Let's see. Who hasn't done one? Can you do this one?
Bob, it's 10 o'clock.
All right. Let's do this real fast, and we can take a break. Are you guys cool with that? Yeah. Everybody okay? All right.
Harry Advocate, Esquire, is representing a client for driving on the revoked list in the municipal court. In reviewing his client's driving history, he notes that although this appears to be the first offense for driving on the revoked list, the driving conduct is related to a second offense, drunk driving. This means the police could have charged his client with a fourth-degree crime. Harry also knows that by pleading guilty to the revoked list offense immediately, he will insulate his client from indictment on double jeopardy grounds. Accordingly, Harry informs the municipal prosecutor that he will be pleading guilty to the ticket and proceeds to enter that plea in open court. What ethical issues are implicated in this case?
What do you think, Joey?
Well, my feeling on this, I mean, Selig notwithstanding, I think this is way different than In re Selig, which we'll discuss in a few minutes. My feeling on this is this. In re Selig had to do with the court being, at least allegedly, ignorant. It forgot facts of the case that were important. This is discussing the law. Now, in this particular issue about the new fourth-degree offense for driving on the revoked list, if it is either driving on the revoked list while suspended for a second or subsequent DWI, or a second driving on the revoked list for being suspended for your first DWI. There is a fourth-degree statute. However, 39450 also deals with a second offense or a first offense revoked list, and there are penalties for that. My position is this. The state knows about the existence of this statute. The state has charging authority and as such has charging discretion. I have to tell you that the majority of my clients that are picked up driving on the revoked list for DWI, where that fourth degree statute will come into effect, they don't bother handing it up to the prosecutor, and only, I don't want to say a tiny percentage, but only a small percentage of my clients are being referred up to be charged under the fourth degree offense. I believe that if the state is charged with being aware, where ignorance of the law is no excuse, clearly, and then with the publicity this has, and in the discussions between municipal prosecutors and cops, everyone knows about the existence of this fourth degree crime. If they choose not to charge your client with that, and even if they later on claim, well, geez, we never checked his abstract, well, that's ridiculous because you checked his abstract to find out whether he was revoked or not. If they choose not to charge your client with the fourth degree and they just want to treat him to the great penalties, the substantial penalties under 39-340, I don't believe you have an obligation to tell them, wait a minute, you could even be harder on my guy. You guys are being too soft. Do you know there's another statute you could really pound him? I don't believe you have that obligation. You can trust, and you should be able to trust, that they know the law and that they've made this decision. I don't believe you are obligated to bring this up.
So let me change the facts then slightly, Joe. All right, I'm going to put you on the spot here. Your guy gets stopped. He's a fourth offender. And there he's driving on the revoked list. You know why he's driving? Because it sure beats walking, okay? He gives his brother's name, who has a valid license, all right? So the cops write him the ticket under the brother's name. He's drunk. They take him in. They charge him, all right? So the guy comes to you. And I know you, Joe, and the first words you out of your mouth is saying, listen, we're not going to perpetrate a fraud on the court. We're going to go in and we're going to stand in front of the judge and we're going to say, no, this is my name and this is my driver's license number, okay? And I'm going to give a writing and I'm going to send a copy to the prosecutor, okay? Now, does that end your obligation, or do you now have an obligation to go farther to the prosecutor and say, listen, my guy lied. He's probably on the revoke list for a fourth degree offense. You may want to check that. Or you just say, once I've told you who my guy is, that completes my obligation.
Yeah, I would say that and I've been in that exact situation, except that I had no idea my guy was lying to me until I took him to court in front of a very crowded courtroom. And the prosecutor was lying in wait, and he had the cops outside, and he says, oh, we're calling the case of Juan Castro. Juan Castro, would you come up? My client and I, we go up there, some other guy walks up over there, and the prosecutor says, my client, who are you? I'm Juan Castro. He says, who are you? I'm Juan Castro. I thought, okay, this isn't going well. My first thought, honestly, was being naive. I thought, wow, I mean, it's not unusual, it's not an unusual name, and there could be two guys by this name. What a coincidence, both on the same night. What's your driving license number? What's yours? I thought, okay, now I know what's happening. My guy had 2 DWIs that I didn't know about. He paid this guy to be able to use his identification to get a license, and so I found out. And so as I'm standing up there, they're handcuffing my client and taking him out of the courtroom. And that was it. I never heard from him again. I swear to God, that's the truth. He paid me to represent him on this case, and I tried calling him, I tried emailing him, I tried writing him. I never heard from him again. I have no idea.
Is that for you in your trust account, Joe? I want to ask you that.
It's a very trusted.
So, but Joe,
my position is, I will not represent someone who wants to continue a fraudulent identity, because I feel that by going into court and not correcting that misimpression that I'm committing an unethical act, I may be aiding and abetting him in defrauding the authority.
But you're not going to do that. You're going to tell the court, this is my guy's name.
Right.
And this is his DL number. But are you done at that point?
I'm done.
All right, so you're going to say to the prosecutor, you want to charge my guy with additional stuff? That's up to you.
Here's his true name. You do whatever investigation you have. This is his true name. I don't think I have to direct their investigators and police officers as to how they should properly continue their investigation.
Let's take a look. Here's RPC 3.3. 5 was the issue in Selig. Now, Selig involved a situation where the lawyer went in and pled his guy guilty to traffic tickets and did not tell the judge that the defendant also had companion aggravated manslaughter criminal complaints that came out of the same incident. He just didn't mention that because he wanted to set up a double jeopardy defense. He never told the judge that these 2 cases existed. In our example, there are no other cases, okay? So 3.3A5, failed to disclose to the tribunal a material fact knowing that its omission is reasonably certain to mislead the tribunal, except shall not be a breach of this rule if the disclosure is protected by a recognized privilege or is otherwise prohibited by law. So that's if it's something given to you in confidence. for example, under RPC 1.6, attorney-client privilege, you'd be okay there. In this particular case, here's the ruling by Chief Justice Porridge. Joey, could you read that, please?
Sure. In this case, the issue is not whether respondent's client obtained a fair trial, but whether, because of double jeopardy considerations, a trial on the indictable offenses would have been possible at all after the municipal court acted. It was what, a reckless driving ticket or something?
One reckless and one leaving the scene.
Right, and he killed two people, two young kids. I mean,
well, that's what the cops say.
Yeah, well, that's what the dead bodies say. But they killed two people in this, and the judge had arraigned him. Didn't he arraign him on the?
Only twice.
Yeah, twice. So the second time back, he's got the records and said, "Let's do this." Now you should know the upshot so that you understand what happened here is. He did plead guilty to the reckless, and then when they found out they had made this mistake, the court found they notified them. So what did the Attorney General's office do? They handled this very professionally and very legally. They said, let's go take a look at the transcript. Look at this. He never gave a factual basis. The judge never asked him for a factual basis. Therefore, there was in effect no admission of guilt from the defendant's own lips, and therefore, this was not a true plea, and that the sentencing is non-volt, and there is no admission of a motor vehicle offense, no double jeopardy issue, because he never actually pled guilty because he didn't invent the factual basis. So they undid it all, and GSCLE here got himself in the jackpot. Basically what they said is, this is the first time we've seen this, and we understand your reasoning, and so we're not going to punish you, because you had no prior warning how to handle your obligations to the court and to your client. They were conflicting for you, and you made a moral decision. However, now that we've made it clear, for everyone in the future, you're not going to get off. In the future, if this comes up, you have an obligation. But I'm getting aside here. The fact that it's this doesn't deal with double jeopardy considerations, and that GSCLE involved. In that context, certainly, the Sixth Amendment right to effective assistance of counsel should not be invoked to thwart the administration of justice. Describing a lawyer as an officer of the court and, like the court itself, an instrument or agency to advance the ends of justice.
Yeah, that's a reference to Nix versus Whiteside, the United States Supreme Court case.
Honestly, if my clients wanted justice, they'd go in pro se. They hired me because justice is the last thing they want. We conclude, therefore, that an attorney in these circumstances here, this is GSCLE now, the circumstances here presented is not prohibited by a client's Sixth Amendment rights or any other duty owed the client from informing the municipal court about a pending indictable offenses, and should do so to prevent the court from being misled by the attorney's silence.
So the distinction we have here is that in our case, there are no other complaints that have been written. And it's not your obligation to tell the prosecutor what he should be charging your client with, or that, listen, my guy pleads guilty today, that's going to end the case forever. I want to bring to everybody's attention, this case, it's not every day that the legislature gets involved with a, attorney disciplinary cases and enacts a statute. But this was such an outrageous abuse of the system. The legislature enacted a statute, it's codified at NJSA 2B:17.2, which makes it, divests municipal courts of jurisdiction ab initio in cases involving death or serious bodily injury. That's to prevent this from happening, where an attorney would go in and actually establish a factual basis to prevent these double jeopardy claims. Did you have a question?
The other side of the coin, my guy gets arrested in a vehicle with an indictable amount of drugs. Mm-hmm. He also receives his third DWI at the same time. We go to Superior Court. We get a probationary term. They forget to bring up the DWI. Mm-hmm. A year later, back to municipal court, double jeopardy.
Yeah, that's State versus Hand. Yeah, they're not supposed to do that anymore. Theoretically, it's supposed to be one-stop shopping, but that happens.
The question that I'm asking is, am I on the hook? That's all I care about.
I don't think so. I mean, the attorney in hand, they never brought that up at all.
Yeah, listen, the prosecuting authority has that ticket in front of him and is making the decision. They're returning it. They're taking the official act of returning it to municipal court, so they can't claim, geez, we were misled. We didn't know we had this ticket. Really, the one that you signed an order that day, returning it to municipal court for further prosecution? No. So,
Joe, are you in a position to talk about how drunk your client is when you plead guilty in Superior Court?
Yes.
Could you mention that to everybody?
Yeah.
This comes up. Listen to Joe's advice. It's good advice.
Yeah, I actually came this close to being able to do this for a client of mine 3 weeks ago. We're right in the middle of it. The prosecutor said, oh, I forgot he's got to plead to the DWI too. I have a client who is charged with drunk driving, and he had his underage child in the car. He had his 9-year-old son in the car. There was an accident. I'll describe it as that, but it was simply nothing more than a minor fender bender. No one was injured or came close to being injured. Nonetheless, my client was ascertained to be intoxicated there. Now, he's also got the offense of endangering the welfare of a child. It's a second-degree offense, mandatory state prison. And they've got my client, he's twice the legal limit, and he looks drunk, and he talks drunk, and we've got 2 veteran officers saying he is drunk, and he admitted to a whole bunch of drinks. So he was going down on that if it would be too risky for him to go to trial. When they offered me a 4th degree, non-custodial, gave the client, the ups and the downs, and no, I'll go with that, because I don't want to risk going to state prison. So I told him, I said, listen, when we put this through, we're going to establish, I'm going to ask you how much you had to drink, you're going to tell me how much you had to drink, because right now they're not requiring you to apply to plead to the DWI. They may be just returning it. So you're going to tell the court that one of the elements of this offense is you had to endanger the welfare of your child, and how did you do it? That's Title IX has essentially the same standard, that you materially put the child in a position of danger and neglect. You're going to say, look, I was drinking, I had too much to drink, I was intoxicated, I was driving, and as such my child was endangered being in a car of someone where his parent is the driver and then the parent is drunk. As I told him we're going to do, I don't want to tell him why I was drunk. Trust me, because they send the DWI down, double jeopardy, you're out of there. Because we've already established as a factual element of this offense, and they have an obligation for mandatory joinder. And just as we're beginning the fact, he said, oh, wait a minute, I'm sorry, Counselor. I was like, Joe, he's got to plead to the DWI too. That's part of the deal. Everything I told you before doesn't count now. And that was it. So, but that's it. If there's any element of the driving, remember, to be convicted of driving while intoxicated, you have to be driving while intoxicated. Those are the 2 most basic elements, right? So if either one of those is a factor, is an element, or even the same factual basis for the plea to the indictable offense, that bars the DWI from being relitigated down below.
State versus Hand, H-A-N-D, is the case. Appellate division case from around 2010. And it's a landmark decision dealing with this particular issue.
Fact pattern number 6, the real estate closing. Los is a real estate attorney who has come to a closing representing the sellers of a residence. At closing, the attorney for the buyers shows up and appears to be visibly intoxicated. In addition, when it comes time to close title, he reveals that the buyers will satisfy the balance of the purchase price with a personal check that he will write. He then proceeds to prepare the personal check payable to the sellers in the full amount due. What ethical issues are implicated in this case?
My responsibility as the seller is to dime them out, but I think I would probably postpone the closing.
Okay.
And say, let's avoid embarrassment here.
All right.
I don't want to find out later something happened.
But Howie, how about if everybody's there, the moving truck is there, the wife is crying, everybody wants to move, the kids are crying because they want to start their new school. The moving van is there, backed up to the house.
What do we do about money?
Yeah, what do we do about money?
Well, what do we do about money? There is no money.
You're not going to close this
I
title?
won't close that.
Okay.
There's no way.
Would you do a dry closing at least?
No.
You wouldn't even do a dry closing?
No.
Wow, that's a bold statement.
Yeah, why not? I mean, just have everyone sign it, keep the documents in trust.
No, I wouldn't do it.
All right.
I would take his trust account check because I'm waiting for the wire to come in, let's say.
Mm-hmm.
If you, let's say it's you and me, we're the attorneys, and you say, Howie, I didn't get the wire yet, it's coming. I go, okay, Bob, I'll tell you what we'll do. Let's dry close. I'll give you the documents, hold them in escrow, give me your checks, I'll hold your check, call me when the wire hits.
Now,
you can't record until I get the money.
Just so everybody understands what we're talking about, in 40 years of practicing law, how many closings do you think you've done?
1,000.
1,000?
About 1,500.
Okay, so I mean, you know what you're talking about here. Okay. Everybody sitting here agrees that this is a problem with this closing, right?
Yes.
Okay. Now let's talk about the ethics part of it. And I want to talk about the ethics, not from the standpoint of the intoxicated lawyer who tries to pay for the proceeds of this closing with a personal check. I don't want to talk about that. That's too easy. I want to talk about the responsibility ethically of the attorney on the other side. When he sees somebody show up at a closing and he's drunk, and he sees somebody on the other side of a closing trying to pay for this with a personal check, does he have an affirmative obligation, as Howie says, to dime the guy out? Yeah. Let's talk about this, though, from, let's simplify it. Would you all agree with me that if you were a part-time municipal court judge, you would have no choice? Rule 1:18 was require you to go forward and report this. Yeah. So, okay, so for judges, yeah, it's there. There it is.
I mean, in court.
In court.
Would the same judge have the requirement in his own private practice of law if someone comes in to, and in that same condition for closing? That's the issue you're getting at.
That's right. And my answer to that would be, there's no doubt about it. It's not even a closed case. Okay. Yeah, absolutely. Because you're a judge 24 hours a day, 7 days a week. Okay. But that's easy. I want to talk about the lawyer. I'm not a cop, right? I mean, that's right. Okay. Now, the problem you're going to see here, this deals with RPC 8.3. I want to vet it a little bit so we can take a look at it, all right? Here's 8.3A. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct. Okay, so let's stop. You have to know, which means you're certain or practically certain that it has happened. It has to be a violation of the RPCs. Not that he's a bad person, not that he's an idiot. There has to be an RPC violation. But it's not every RPC violation. It's more nuanced than that. It's an RPC violation that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Now, at this closing table, do you see evidence that there's been misconduct here that relates to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects? Why is he paying for something on behalf of a client with a personal check?
Because I think he's drunk.
Okay. But does that mean that he got money that belonged to a client and put it in his personal account? But I'm concerned that you might have an implication here. First of all, a guy who shows up at closing, the argument can be made that it raises a substantial question as to his fitness as a lawyer in other respects. Maybe this guy's an alcoholic. Maybe he's drunk 24 hours a day. Maybe he's endangering his clients and members of the public by being so intoxicated. Maybe he drove here drunk on top of everything else. Now, the other part about honesty and trustworthiness, if you're purporting to pay for a client with a personal check, at a minimum, it implicates the possibility of commingling funds. Either you got a loan or, the client gave you money, you put it in your personal account or something of that nature. It's something that has to be investigated. The key is this serious enough? What is the tipping point where you feel you're obligated to go forward and report this either to the Office of Attorney Ethics or to the District Ethics Committee, okay? The client's not going to be subject to any RPC issues. The attorney who does not report it could be under 8.3A, okay? So here's the problem that we're running into. I mean, it's not clear at all. I know a lot of you guys have misgivings about this, okay? My own advice would be go forward and report it, let the chips fall where they may. I'd rather see him get jammed up than you get jammed up for not reporting him. This RPC has not been construed by the New Jersey Supreme Court yet. The cases on it are really very poorly discussed by the DRB, primarily because there's so many other things going on in the cases involving these guys that it's really a very minor issue to the point where, and it's usually partners working in the firm, and they should have been reporting each other for ongoing, using runners and ripping clients off. Each one knows about it and doesn't do anything to report his partner. Here's all the cases. Fusco and Macaluso are companion cases. They were partners at a firm. The DRB felt that Fusco was the more culpable of the two, so that's why he wound up getting a 3-month suspension as opposed to Macaluso got a censure. I think this is the case where they had the guy who had been a former claims adjuster, okay, and we're paying him a salary but a commission on top of that. You guys remember the case?
Splitting attorney's fees with a non-lawyer.
Right. And the guy was making more money than the lawyers were. I mean, it was just, this guy was doing good. I want to get some of that action. But the fact is that each of them knew what the other attorney was doing, and neither one of them reported it, so they got jammed up under 8.3. Here's a little bit of language. Here, respondents argued that because they did not believe that the conduct was unethical, they had no reason to report it, okay? The court has long held that ignorance of the rules is not a defense to the charges of unethical conduct. In Berkowitz, lawyers are expected to be fully versed in the ethics rules that regulate their conduct. ignorance or gross misunderstanding of those rules does not excuse misconduct. Joey, could you read the Eisenberg quote? I love this.
I will. We view with increasing concern the practice of attorneys facing discipline by this court to treat the applicable disciplinary rules as terra incognita, the unknown territory. Although this astonishing lack of familiarities with the rules is sometimes characterized as a, quote, defense, ignorance of our ethical rules and case law cannot be permitted to diminish responsibility for conduct in violation of these rules. Now, if you remember Steve Martin years ago on an appearance on Saturday Night Live, he did a stand-up bit where he talked about the fact that, you can always plead ignorance. I forgot that armed robbery was against the law. That was his refrain. I forgot.
What do I say to the tax man when he comes to my door and says, you have never paid taxes? Two simple words. Two simple words in the English language. I forgot. How many times do we let ourselves get into terrible situations because we don't say, I forgot? Let's say you're on trial for armed robbery. You say to the judge, I forgot armed robbery was illegal.
And now that's so ridiculous that the audience laughed hysterically. But the Supreme Court is saying lawyers are actually saying that stupid thing as a defense to them. I didn't realize it was, I don't know the rules of ethics, so you can't really hold me to them.
They're going to speak in Latin. What do they expect from us, man?
That's a good point.
The Bonfeld, Gold, and Tomar are the only other cases discussed. Is Gold and Tomar post RPC cases, but again, no intelligent discussing the parameters of this. So until the Supreme Court comes along and construes it a little bit better, you're really kind of left to your own devices. But I want everybody to know that it's out there, and then you use your own judgment. Just please be aware of the fact that you yourself could get jammed up for failure to go forward and report this, especially if your client goes, or one of the lay people there makes a big issue of it. They're going to turn and say, why didn't you do something? You're the lawyer. You should have known better.
Fact pattern number 7. Whoops! During the course of a drunk driving trial, the municipal court prosecutor learns from a defense attorney that the Alka-Test license of a police officer who periodically changes the solution of the department's Alka-Test machine had expired a year ago. This solution must be changed at least every 30 days. After a check of the department's records, the prosecutor calculates that the officer changed the solution on the Alka-Test 6 times during a 1-year period. NJAC 13:51-1.8D renders the results of a test taken by an officer with an expired license inadmissible. What ethical issues are implicated in this case? Yeah!
Now, Joe, let me hit you with an idea. I'm the municipal prosecutor, and here's my position. Listen, I sent all these retards the discovery package, okay? 180 of them went out. Is it my fault that 179 guys didn't pick up on it? No. Everybody had the same discovery. Only one guy raised the issue. That guy gets a break. The rest of them, forget about it. What do you say?
I got to tell you, that's not such a half-bad idea, but in this particular case, which is a Bergen County municipality, the prosecutor called up, I happen to know the behind-the-scenes story, he called up the county prosecutor and said, look, we just uncovered the situation, what do we do? And I think you could argue that, hey, the defense attorneys were looking through, they should have seen that the officer's Alka-Test card had expired, and that he didn't have the right, therefore, to change the simulated solution. But they said, no, do you know what? We're going to take the high road. File a motion with the court that you want to reopen all these cases and notify all the attorneys whose clients pled guilty or were convicted as a result of a reading, and or a case involving a reading, and let them, if they want to reopen, great, and if they don't, then they don't. But put everyone on notice. I thought that was the high road. I was very impressed. Now, I got one of the notices, but I had already had the Alka-Test results excluded for other reasons, and they didn't play a factor in my case, in resolving the case. So I did not take part in this mass, I want to open it up again. But that's how they did it. And I thought, even though I don't think that was necessarily...
Is it a small town?
Yeah, it was.
Okay.
And I thought that even though they didn't necessarily have an ethical obligation, because this was something that should have been checked by the defense attorney in the discovery, I thought you can never go wrong by taking the ethical, very high road, and especially when you're the government, setting the example for everyone else. So I think that this was absolutely the correct thing to do, and I'm very proud of that municipality for having done it.
Joe, a couple of issues. Number one, could the prosecutor say, listen, it would only matter where there was a per se violation, where the BAC was, under, I mean, if the guy was convicted, if it was a second offense or a third offense and he was under the influence of alcohol, it's irrelevant. So we have a very, very small number of people that this might be applicable to, and then it's only a resentencing issue, assuming the guy's under the influence of alcohol.
My recollection is, this case is, this was Bergenfield, by the way, I mean, this is public knowledge. In that year, only 13 defendants were affected by this.
Yeah.
13.
Now
it does, here's the people that affected most. For me, it's a plea. Sometimes you'll advance an argument to the prosecutor, which is a legitimate argument. Maybe it's not actually set forth in chun, but it is a legitimate argument. Say, look, if your guy will plead guilty to a 3-month, we'll get rid of the reading because this is a legitimate argument. We can put this on the record, and the judge accepts this as a legitimate argument. But if you know that alcohol test reading was out anyway, then your client has nothing to worry about in terms of going to trial. The worst that can happen is the same thing as if he pleads guilty.
Joe, I really want to put you on the spot now, all right? We all know that RPC 3.8 is the ethical responsibility of prosecutors. Here it is right here. Okay, there's 3.8. Again, what we're talking about here is D, make time and disclosure in defense of all evidence known to the prosecutor that tends to negate guilt of the accuser or mitigates the offense in connection with sentencing. All right, so I mean, D is definitely in play in your issue. We would all agree, and this is the comment from the Supreme Court, prosecutor's function is not to really seek convictions in all cases, not an ordinary advocate, obligation to defendants to state in public to see that justice be done and the truth be revealed in each individual case. The goal to be to achieve individual justice in individual cases, okay? Now, having said that, I want to hear your comments about the Ferguson fiasco. Did the prosecutor do the right thing there in this so-called data dump, giving it all to the grand jury and let them make the call? Was it ethical for him to do it that way in the sense that he is not an ordinary advocate, he's there to do justice as opposed to merely seek conviction? Or was this ducking his responsibility to seek a conviction and let the jury make the call?
I honestly don't believe, just as I said before, that you can't be too ethical. I don't believe that you could be really accused of anything improper if you lay out all the information. All the information. Now, suppose the defendant had a prior criminal record. Not that I know of. He might have had minor things, but not criminal record. Should the grand jury know that the victim had prior run-ins with the police? Yeah, that may be relevant as to his attitude towards the police department, maybe. So I don't think that if you give them too much information, I shouldn't say too much, all the information, that someone can say you're hiding anything. He had an obligation, the prosecutor in Missouri had an obligation to not only do justice, but make it appear as if justice was done. And if he selectively chose what evidence went before the grand jury, and that got out, the community at large might say you cherry-picked the things that were advantageous to the state. By laying it all out there, he's not open to that charge, and maybe if that gets out, listen, we gave him all the information, including your medical examiner, Dr. Albano, came in and, was it Baden? I'm sorry, Baden.
Baden testified for the family.
Right. Baden did a defense autopsy, and they had Baden put his defense autopsy before that grand jury. So I think that, listen, my opinion from what little I know of the case, and all I know, honestly, is what I've read in the newspapers, I don't believe that you could fault the state for giving the grand jury all the information and going the extra step, letting the expert.
All I'm bringing the reason for the purpose of this discussion is to sensitize everybody to these very, very nuanced, highly complex, and sometimes highly charged political issues. The grand jury has a function that's not only accusatory but investigatory, and sometimes these distinctions get blurred, but that's the traditional function of the grand jury. My concern is whether or not the prosecutor was acting in conformity with RPC 3.8. So, again, no right answer, just to sensitize everybody to it.
Fact pattern number 8. The crazy client. Larry the lawyer holds the unique distinction of being the only New Jersey lawyer in history to ever represent a crazy client. He represents her in a personal injury case in Essex County. Due to the crowded civil docket in Superior Court, many months go by without any development in his client's case. However, she is extremely demanding and calls the office almost daily, demanding to speak with Larry or writing long accusatory emails to which Larry has long ago given up responding or even reading. Larry would like to get rid of her as a client, but the value of the case would make that a bad business decision. The client is now threatening to file an ethics complaint unless Larry communicates with her about the case. What ethical issues are implicated in this case?
Let's look at the RPCs. Now look, just A and C deal with prospective clients. A exclusively with prospective clients, okay? Lawyer shall inform a prospective client of how, when, and where the client may communicate with the lawyer. Guys, email, and more email. You'll have a record of the communication back and forth. The reasonableness of your efforts to communicate with your client will be much more discernible when you have this type of a record. You can communicate at times that are convenient for you. You can do it in a cursory manner and yet satisfy the obligation to communicate with your client. Now, C deals not only with prospective clients, it comes up a lot in the context of fee agreements where there is no fee agreement or the fee agreement is written so poorly that you don't know what the hourly rate is or the basis of the billing, who's going to be responsible for expenses and things like that. Many times it also comes down where clients have not been given information to make a decision on the case, whether the case should be settled, whether the client should take a particular tactic or adopt a particular strategy. You just haven't given your client enough information to make that determination. Going back to A for a second, for those of you who have websites where you invite clients to contact you by email, and you'll send them answers, RPC at 1.4a is implicated by that. Make sure that you have a method for communicating with your client. You tell them how they communicate with you. They are prospective clients. They come within A. Not only that, make sure that the confidentiality requirements of prospective clients is protected under RPC 1.6, and make sure that the responses, the legal advice that's going there is not coming from your secretary, it's coming from a licensed New Jersey attorney over whom you have, authority, okay? Very important when you have that kind of stuff on your website. Now, I want you to vet B a little bit. What is your responsibility? You have an obligation to keep your client reasonably informed, okay? Only reasonably informed about the status of the matter. Your obligation to properly respond to requests for information is only when those requests are reasonable. So you don't have to tell your client about every sparrow that falls out of a tree. Your client only has to be reasonably informed. And requests for information, you have an obligation to respond promptly only when that request is reasonable. So when your client steps over the line, becomes unreasonable by contacting you every minute of the day and night, you don't have an affirmative obligation to go forward and do that, okay? But RPC is basically the main one dealing with communications that controls all this stuff. All right. Now, who has not gone yet? I know somebody's hiding here. No. Can you try?
Fact pattern number 9, the referral. Lawyer Luke is a solo practitioner operating as an LLC. He has a good deal of experience in handling automobile personal injury cases. Because he has such a solid reputation, Lawyer Mark refers a plaintiff's case to him with lots of insurance coverage and good liability. Luke accepts the case. He has a client sign a fee agreement and begins to work on the file. Unfortunately, due to a clerical error, Luke does not file a lawsuit in time and the applicable statute runs. Moreover, Luke has no malpractice coverage. What ethical issues are implicated in this case?
Okay, so let's start off with Lawyer Luke. Lawyer Luke's got big problems, okay? He let a statute run that had a lot of liability and a lot of insurance, okay? So he's got negligence and diligence as preliminary issues. He's practicing an LLC, and the court rule, I think it's 1:21-6, says you cannot practice as an LLC or a corporation or anything else without a liability policy of at least $100,000, right? Everybody understand?
Yeah, I think no greater than a $5,000 deductible.
Mm-hmm. So the whole idea here is that you're not going to be able to shelter yourself from liability through the LLC. If you're a solo, you don't have to have any liability insurance because you're a solo. You know, your own assets are in play. But for this guy, he's got an RPC violation because he didn't comply with the rules of court. Okay? All right. So far so good. He's the easy call. What about Lawyer Mark, the guy who referred it over? Does Lawyer Mark have any ethical problems?
No, but does Lawyer Mark have an issue where he may be just as culpable or partially culpable?
Well, that's what I'm asking.
Yeah. No,
does he have an ethical issue here? But when you got a lot of money at stake, due diligence. Do you have an obligation affirmatively to find out that the guy you're sending this case to, that you're going to entrust your client's future to with all this money, that at least has liability insurance? Is that asking a lot?
No, I'd be more concerned
After the
if he
fact,
was
it's
a
not,
drinker.
but you know, that's the problem.
Well, then the next step is, then the issue against you is, you know, he should have asked about malpractice. I did. He told me he did.
All right,
He lied.
Okay, that's fine. Or he was
You
mistaken.
have to ask him if he has any drug charges pending, if he beat his wife. I mean,
Did he come to closing's drunk?
Yeah, does he come up, does he drink?
No, Bob, these are all good issues. These are all good issues. Now, of course, one of the problems here is if Lawyer Luke is not a certified trial attorney, he can't accept a referral fee. If under these circumstances, without being a certified civil trial attorney,
Lawyer Mark.
He didn't do any work on the file. He's just sending it over.
He just shipped it over.
okay, I'm sorry, Lawyer Mark. If Lawyer Mark, who is referring the case, is a certified civil trial attorney, however, he doesn't do, you know, this may be, let's say, a malpractice case, and that he wants Luke, who's the malpractice plaintiff specialist, to handle it. If he's not a civil trial attorney and he gets a referral fee, then that would only be because he participated in the work. And if he participating in the work, he should have been following the statute of limitations, and that may make him responsible for missing the statute of limitations.
Luke would be certified, not Mark. And if Luke is certified, he's the one that refers it back.
Right, Luke would have to be certified to pay it back.
Mark would only be entitled to a quantum merit.
There's another procedure within RPCs about if you're not certified with a referral fee, but there's a procedure you have to go through.
Yeah, you got to justify the work that you did.
Yeah, you have to. No, you do. You have to.
Without the quantum of work.
Quantum merit.
Right. Yeah. So that, but you have to work on it. One of the things that if you're working on a case, you want to make sure the SOL is fulfilled.
The whole idea here, though, is to sensitize you guys to these RPCs. The civil part of this, it'll work itself out one way or the other. Everybody's jammed up here. I'm mostly concerned about what are the exposure from an ethics standpoint. Here's 1.1. Lawyer shall not, and you have A, handle a matter, entrust the lawyer in such a matter that the lawyer constitutes gross neglect. So the guy who lets a statute run where you're dealing with a lot of liability coverage, or a lot of insurance and good liability, it's going to be gross negligence. Gross negligence is not defined in the RPCs, but it's a function of harm to the client. If the client's walking away from a big payday, that's gross negligence, all right? An individual act of negligence is not an RPC violation, okay? A single act, though, of gross negligence is. It's a 1.1A. B, exhibit a pattern of negligence or neglect in the lawyer's handling of matters generally. Now, I will tell you, pattern is not defined in the RPCs either. It's defined in the case law, and it's basically 2 or more acts of negligence constitutes a pattern, all right? 2 or more. So just kind of keep that in the back of your mind when you're dealing with this stuff. Diligence, lawyer shall act with reasonable diligence and promptness in representing a client. So for the guy who lets the statute run, you have no problem with 1.3. You certainly have no problem with 1.1A. Can you make a case that Lawyer Mark, who referred this over without checking to see whether the guy had liability insurance, could get jammed up under this?
About a 1.3
case.
Either 1.3 or 1.1. Was he grossly negligent and failing to do due diligence?
Jesus, that's gross negligence. We're all in trouble.
Well, we're all in trouble anyway. All right.
Did they? Let's go see Maurice now.
You know, there is a Bergen County case pending right now, a civil case, and I won't be more specific than I have to be, although we're all intimately familiar with the knowledge, where there was a law firm in Bergen County with a senior partner and a junior partner. And the senior partner had some notoriety, and the senior partner blew a statute of limitations, never told the client, pretended to the client that they were going through depositions, and then told the client it was settled. And then the senior partner died. Now the junior partner, the much junior partner, the young guy, he's being sued for malpractice on the allegation that he had an obligation to watch over all the cases of the senior partner and supervise him and make sure he was doing everything correctly. Now, we in this business know that's ludicrous. Nonetheless, you know, if you're a plaintiff's attorney, you're alleging everything that might get you some money, and there was no malpractice policy in his office. Why? Because when it came time for renewal, the senior partner didn't even want to admit to his malpractice carrier that he had screwed up, didn't tell them, thereby committing fraud and voiding the policy. So the poor younger attorney, even though it's not an ethics manner, but it is consistent with the ethics theory Bob is asking about at the very least, is can you say that the younger junior partner had an obligation to supervise the senior partner, make sure he was doing everything correctly?
Here's number 10. Joe, could you do this one personally? Because I think about you all the time in this one.
Sam practices law in Millville. A new client has stopped by for a consultation about a drunk driving case in nearby Maurice River Township. The prospective client relates that this would be a second offense, although his prior conviction was more than 13 years ago. He thinks his BAC was a .17. He also relates that he thinks the only reason the trooper stopped him was that he was seen pulling out of a bar on Route 47. He is concerned about losing his license for years and terrified about going to jail. Sam demands a $10,000 retainer to represent him, with an additional $7,500 if the matter is tried in municipal court. What ethical issues are implicated in this case?
Your name always comes up every time we discuss this. No matter where I go, they mention you.
I'm reducing my fees to that, by the way.
No, it's Joe, and you'll see why in a few moments. So what are your thoughts, Joey?
Well, first of all, his exposure is minimal. It's a first time. He'll be sentenced as a first offense. It's a second offense to be sentenced as a first time offense, assuming that we'll assume that everything he tells the lawyer was accurate. And he expresses a fear that he's going to go to jail. The lawyer knows that unless, I mean, he was only stopped for some motor vehicle offense. There was no accident or injuries. The lawyer knows that the chances of him going to jail are as close to zero as possible. Sure, might he get an 8 or 9 month suspension as opposed to 7? Sure, the judge may take into account the first one and give him an extra month or 2. That's very unlikely. It's by far the exception rather than the rule, but on rare occasion you could tell him he does have that possible concern. Now, is this a particularly difficult case? What are lawyers around the state generally charging for such offenses? Well, depending on where you go, depending on the experience of the lawyer, you're talking about, I would think, the general ballpark, maybe 1 or 2 are out of this range, between $1,000 and $5,000. Now, he's talking about $10,000, and if trial 17.5, I think that is grossly disproportionate to what the client is facing, and it doesn't say in this fact pattern that he advises the client, look, you're going to be sentenced as a first offender, you're not going to lose your license for years, worst you're going to lose it for is 1 year, and probably less. Yes, there is a statute here that says you can go to jail. The chances of it being imposed are so small as to not really warrant much concern on your part. I can't tell you it couldn't happen. I'm just telling you it's extremely unlikely. So and then after you tell him that, then he'll be in a position to say, well, that's all I'm facing. I don't want to pay $10,000 or $17,500. I think that the lawyer is not being honest with the client in setting the fee, not accurately apprising him of what the real world consequences of his actions are, and that he's overreaching. So I would find that lawyer's conduct to be despicable. The question is unethical, and I think that it bleeds over into unethical conduct because he's taking money from this client under quasi-false pretense.
Okay. Now, Joe's used the magic word here is overreaching, okay? And what we have to discuss here is overreaching. Were you guys aware that there's a place in New Jersey, by the way, called Cumberland County? Who knew, Cumberland is the poorest county in the state. I will tell you it's populated with absolutely wonderful people. We teach down there a lot. But it's a very poor rural county, okay? And
what's the county seat?
Bridgeton. Yeah, who knew, right?
Isn't that what both the Superior Court judges said?
Yeah. The Millville is an old glass blowing town. That was their claim to fame. They had glass blowing factories there that were going in the 1800s and the first part of the 20th century. But apart from that, there's really not a whole lot going on down there of economic activity. So you're dealing with an attorney who's representing a client in the poorest, lowest income county in the state. And he ain't no Joe Rem. Now take Joe Rem in the middle of Bergen County, who has close to 40 years of experience, of which 35 was spent trying drunk driving cases. In any list of the top 10 attorneys for drunk driving defense, Joe's going to be right up there in the top 5. And Joe will give you a fanatical, zealous defense on your charge, on your case, okay? So, does it matter that Joe Rem can charge a higher fee because he's an experienced attorney in Bergen County as opposed to a less experienced, less well-known attorney in Cumberland County? Should that matter? Does that go into the mix of overreaching? But you know what, guys, I think what we're saying here implicitly in our discussion is that all fees are not created equal. So location makes a difference. Experience makes a difference. Reputation makes a difference. Joe is going to put in as much time as it takes to defend the case, right?
It could be 5 hours.
And it could be 50, and it could be, yeah, it could be anything.
I've gotten killed on fees where I've charged $5,000 and I literally put in 85 hours. Did I ask the client for 1 penny more? No. Did the client offer more money? Yes. And I turned it down because my agreement was $5,000 for this case, and that's all I would take from the client.
Yeah.
Now, on the other hand, sometimes it's 5 hours.
I do the same thing.
No, but I mean, but sometimes it's a 5-hour case, and your client gets acquitted. I'm not giving money back to the client either. He asked me to get him acquitted. I only put in 5 hours. I earned that $5,000. If I got him acquitted, I did what I said. My fee protects him on the high end and protects me on the low end. This is the flat fee, and I'm going to do whatever amount of work or however little work it takes to get you the result you want.
Let's take a look at the RPC. It's 1.5, guys, all right? So this is the balancing act that you utilize to figure out whether or not a fee is reasonable or overreaching. All right. The fee has to be reasonable. Okay, that's the starting point. We all recognize that it has to be a reasonable fee. Factors to be considered are the following, and you just weigh and evaluate all these things. Time and labor required, novelty and difficulty of the question involved, and the skill requisite to perform the legal service properly. Now I'm going to tell you something, guys. This skill business is important because, you know, Joe Rem will look at a case, read a police report over, and the legal issues will literally jump off the page and slap him upside the side of the head. Whereas lawyers who are not that skilled or experienced will be reading it and they'll just be oblivious to what are very powerful defenses. So, and am I overstating the case here, Joe, or is this, you agree with me?
The more you do one particular area of law, the more issues you become sensitive to.
What a nice lawyerly way to say that.
Well,
he's been slapped in the head many times by the fact.
But I mean, Joe, I mean, this stuff just leaps off the page at you if you see something, right?
Yeah.
Yep.
Oftentimes.
The likelihood of apparent to the client that the acceptance of the particular employment will preclude other employment by the lawyer, that's normally not going to happen in the drunk driving context. Fee customarily charged in the locality for similar legal services. Okay, that's exactly the point that you brought up, Joey. And I would expect you're going to see a huge distinction between fees in Cumberland County as opposed to Bergen County. All right? Amount involved in the results obtained. I don't think that this would be something that would be in play in a criminal or quasi-criminal case, because you're not paying for results, you're paying for effort, skill, experience, that type of thing. Time limitations imposed by the client or by the circumstances. Now, this may be a situation where the case is going to be tried next week. There's not going to be any adjournment at all. It's more than 60 days old or whatever. You know, the guy's just fired his other attorney, and now you're stuck and you got a peremptory trial date. Nature and length of the professional relationship with the client. Experience, reputation, ability of the lawyer or lawyers performing the service. Again, that goes back to, you relate that coupled with location. And finally, whether the fee is fixed or contingent. Again, you're not going to get contingent fees in these types of cases, all right? Now, under B, this comes up a lot in fee arbitration cases where you don't have a retainer agreement with your client, okay? When the lawyer is not regularly represented the client, the basis of the rate shall be communicated in writing to the client before or within a reasonable time after commencing the representation, okay? Now, if you have represented the client previously, you really don't need to have, except in a matrimonial context, you don't need to have a retainer agreement because you have a course of dealing and usage in the trade, so to speak, between you and your client. It's only for the brand new client that you have this particular issue coming up, okay? So I just want everybody to be kind of, you know, sensitized to this stuff, okay? Now, one quick thing I wanted to mention to everybody, these are just little bonus materials, so to speak. Here's your homework assignment today. When you go back to your office, please take 5 minutes and read over Rule 1:21-6, all right? This is another one of those examples of an interplay between the rules of court and the RPCs. RPC 1.15 is the RPC dealing with the ethical requirements of lawyers handling money or property that comes into their possession from a client, all right? It's a strategic, you know, requirement ethically. The actual tactical things that you're supposed to do are set forth in painstaking detail in 121.6. And you should read it over and say to yourself, am I doing this, am I doing this, am I doing this, am I doing this, okay? Look at all the things that you're supposed to be doing as an attorney and make sure that you're in compliance with the rule. Because when you get, you know, when they call you for a random audit, you know, this is exactly what they're going to be looking for. You can head all this off now by taking 5 minutes, reading the court rule, and seeing whether or not, you know, assure yourself that you're obeying everything you're supposed to do. Rule 1:20-20 is the most important rule in terms of ethics. All the attorney ethics rules are in Rule 1:20. 1:20-20 is the most important because it deals with the obligations of attorneys who are suspended or disbarred. If you have a client who's going to be suspended from practice, you've got to make sure that they comply with Rule 1:20-20. Normally, your suspension period won't even begin to run until you present proof that you've complied with the requirements of 1:20-20. Typically, it's going to mean taking the affirmative steps to excise yourself from any reference to you in the world as an attorney. Take down your signs, take your name off the office door, get rid of your business cards. Call every single one of your clients and tell them that you've been suspended from practice. It's a pain in the neck. Now, it's a little bit easier for suspensions that are 6 months or less. But for suspensions that are 6 months or greater, it's a pretty onerous task. So just if you're going to represent somebody who's going to be getting suspended, make sure you familiarize yourself and your client with Rule 1:20-20. 8.1 is your obligation to cooperate affirmatively in an ethics investigation. So if you have like a demand audit, or you have a random audit, or there's some type of a grievance that's filed against you or an inquiry and they want a response from you, you've got to take it seriously and respond promptly, because if you don't, they're going to charge you with this additional RPC violation of 8.1, which is the general requirement that you cooperate fully, completely, and candidly in the ethics and process. And finally, for those of you who are doing any type of advertising at all, advertising is controlled by RPC 7.2 and 7.3. This would include not only television, radio, newspaper, and things of that nature, direct mail, but also internet. There are special rules for internet advertising which you could run afoul of, even inadvertently. Make sure you're familiar with the requirements under RPC 7.2 and 7.3, as well as the Committee on Attorney Advertising Opinions, CAA. Okay, they're all on the judiciary website.
You could trip a foul. Maybe you're best lawyer, or best lawyer in New Jersey, best lawyer in the metropolitan area, super lawyer. You know that you can't put that on your website unless you put somewhere that people can reach what the qualifications are, what, you know, let's say the super lawyers, how they judge people to be super lawyers, and what information. Now, you might want to just put a link sending them to that list, and that would be okay. You might want to spell out all those qualifications, but you just can't say I'm a super lawyer. You have to say, and here's how super lawyers are chosen, and here's their standards, and you can go to this website or look on my last page.
The other thing, too, of course, there's nothing to prevent your clients from going out on their own social sites and saying how great you were, things of that nature. We still have a First Amendment. It's just you better make sure you have a Chinese wall between the accolades your client gives you on some type of website and yourself. It's got to come totally from your client. As in so many areas in life, the technology, the development of the technology is running way, way, way ahead of the development of the RPCs. They just can't keep up to it. And every time they think they do, there's some new thing that comes up. You know, Twitter and Facebook and all this stuff. None of this stuff is addressed in the rules, so you really just have to kind of do the best you can when you're stumbling around in the dark.
Yeah, I kind of analogize to that. You know, we're in the Twitter, Instagram, Snapchat world, And the Supreme Court and its rules and regulations are in the 8-track cassette tape world. And just there's a gap.
Just to give you an example, there was a decision written by Chief Justice Wilentz back in the 80s where he says that it would be harmful to the bar to have New Jersey attorneys have television commercials which contain music and lyrics, okay? You know, as a New Jersey attorney, if you're going to put an ad on TV, you can't have music in your ad. Do you know that? Is that the most ridiculous thing you ever heard in your life? I mean, but this is something that's been hanging on there for 35 years or whatever it's been, and it puts attorneys in New Jersey at a disadvantage against these gigantic markets in New York City and Philadelphia that are blasting in all kinds of crazy advertisements 24 hours a day with music and symphony orchestras and angels singing and all this other stuff. Cartoon characters, too. You can't use cartoon images, okay, in a commercial. They have to be predominantly informational. They can't be... You got to take Tweety Bird out. You know what else you can't do, guys? You're not allowed to use an image of a judge in your internet advertising, your television advertising. Even a cartoon picture of a judge. Even a picture of a judge who's been dead for 400 years. Can't do it. All right? So, I mean, it's out there. I'm not arguing one way or the other in terms of its ridiculousness. I just want everybody to be aware that you have extremely severe restrictions on your ability to advertise in New Jersey, especially over the internet. Please be aware of them before you start doing this kind of stuff, okay? Do you guys have a good time today or a bad time? Good time. You sure? All right. Again, the whole idea here was just to sensitize you guys to this stuff.